Any mention?
Looks on it.
May it please, Your Lordship?
Yes.
Lordship, I beg to mention item 40. Item 40.
1-4.
40.
Where's Mr. Yubin?
It's not in station, Your Lordship.
Yes, sir.
1 week's time, Your Lordship.
It'll go to 4 weeks. Just after 4 weeks, yes, on the request of MSS Islalu. Ilalu, sorry.
Be obliged.
As he.
Your Lordship, I beg to mention item 49 and 50, Your Lordship.
Item number?
49 and 50, Your Lordship.
I can't hear you.
49 and 50, Your Lordship.
Be clear, speak up. We are supposed to be a lawyer. Yes. You have to speak for your clients. Yes, 49 and 50.
Yes, Your Lordship. Connected matters, Your Lordship.
Why?
A personal difficulty, Your Lordship. Already informed the other side.
4 weeks, yes.
That is right, Your Lordship.
49 50.
My Lord, I
Yes.
beg to mention item number 29, my Lord. My Lord has allowed me to file a written synopsis in this matter, my Lord.
29?
My Lord. I'm praying for another 1 week time, my Lord. So the contempt matter, my Lord.
4 weeks will give you. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item 30 and 35. They are connected matters.
30 and 35. Nazrul Islam and where's Mr. Devnath's case? You informed him?
No, Your Lordship.
You've informed?
No, Your Lordship.
You inform him first before you take adjournment? Yes. Any other matter?
Similar prayer for item 32. The
32?
conducting counsel is out of station.
Transfer matters, madam. This 32.
32 with
Yokumar.
46? 46, 47, 48.
46, 47, 48 probably, madam.
They'll all go after 4 weeks. 41, 48 and the other one, whatever. There's also 4 weeks a request for the councils for the parties. Yes.
Your Lordship, item 45
Where's Mr. Changreso?
is out of station, Your Lordship.
45. Yes, 4 weeks, yes.
No objection, Your Lordship.
Your Lordship,
The other two, you inform Mr. Debnath that there is out of which is the first one you mentioned? He's here.
30 and 35.
Nazrul Islam. You ready today? They're seeking time. Okay. Okay. That is item number
30 and 35, Nasrul Islam.
Nazrul Islam, 30 and 35.
Yes, sir. Yes, Your Lordship.
Yes, 4 weeks, yes, 30, 35.
Your Lordship, another item 44.
The whole list is gone.
And for the respondent.
Garikhana Masjid Committee.
Yes, ma'am.
You have objections?
No, ma'am. After 2 weeks, ma'am.
4 weeks, yes.
Hello,
Yes.
Lordship, I beg to make a mention of 37 and 38, my Lord.
Other side's whom? Mr. Sheikh, no objection? Yes, this matter after 4 weeks, yes.
Obliged.
Hello.
Yes.
May I please, Lordship? Lordship, item number 34. The similar matter, Lordship, pending before the division bench. It's coming 26th.
4 weeks. Any hearing matter left?
Lordship, I just want to know
Yes.
whether item number 49, Mr. Nobody has sought time?
Yes, 49, yes. 4 weeks. After 4 weeks, Mr. Janta. Yes. Actually, where's that Mr. who mentioned the matter? You didn't inform the other side.
Yes, Your Lordship.
You didn't inform the other side.
I was not the one who mentioned. It was someone
No, I know. You didn't, not you. You didn't inform the other side. Why?
I was informed by my senior that they have talked in the morning, Your Lordship.
Okay, yes. Yes.
Main list, item number 1.
Your Lordship,
1 second. Aye.
May I plead your lordship, may this matter come at the end of the bottom, your lordship?
Why? The contempt
The
matter?
conducting counsel is
Please,
not in your
Lordship.
lordship.
Lordship, there's nothing else which survives. The order which your Lordship has passed was for not to allow the termination order to survive. So, Lordship, the petitioner had sent her joining letter, and we have accepted joining letter. She's joining.
You show a document to her. Otherwise, a person have to appear in person here.
Yes,
Please, Lordship. Lordship, you can find at the bottom of the page there's a seal which shows that the office has accepted the joining report.
You've seen it, you read it.
yes, your lordship. I'm just not properly briefed with the facts, your lordship. So
Okay, we'll take up some time, you show it to your senior.
Okay. Much obliged, your lordship.
Supplementary list, item number 1.
Yeah, please, Lord.
Yes.
Lord, this writ petition is being filed after respondent number 4 failed to convene a general meeting.
After?
Respondent number 4 failed to convene a general
Failed
meeting.
to convene a general meeting.
Yes, Lord.
Where is the council?
I'm here.
Yes. Yes.
Your Lordship, earlier a writ petition was being filed and the same was disposed of upon the District Council issued a direction to the respondent number 4 to convene a meeting.
Regarding what? This is from which part and what is the background facts?
My Lord, here the village was bifurcated, was created from the main village, that is Nginyong village, in the year 2000.
What bifurcated from?
The main village.
Okay.
In the year 2000. Then in the year 2006, the village was renamed as Maulum Nginyong.
After it was bifurcated.
Yes, my Lord.
Then?
So subsequently, there's a challenge regarding the. Subsequently, the respondent number 3, CM of Miriao, appointed the respondent number 4 as an acting Sodar of Maulum Nginyong. So after the
new village,
they created after they changed the name of the village from Maulum Nginyong to Maulum Ramkadai, then the CM of Miriao issued a sanat and appoint the respondent number 4 as a acting Sodar. So subsequently the was challenged in the year 2000.
So I don't understand. Now your village you see bifurcated from a parent village.
Yes.
What is the name of the parent village?
Nginyong village.
Nginyong village. So
And
what is your new
they
village
created
called?
This village Maulum village.
Maulum. You want to call Maulum Nginyong.
Nginyong.
Yeah. So what happened after
In the year
that?
2006,
after you got a new village, 2006, then
the name of the village was changed to Maulum Ramkadai.
So you changed the name.
Yes, ma'am.
To Ramkadai. Okay. Then what happened? So
After-
Maulum Nginyong ceased to exist.
Then in the year 2010, the CM of Miriao issued sanat to respondent number 4 as acting Sodar of Maulum Nginyong village.
Which is non-existent according to you.
Yes, ma'am.
Then what
So
happened?
after then in the year 2010 itself, the then Sodar, now expired, the then Sodar has challenged the appointment of respondent number 4 as acting Sodar of Maulum Nginyong. So subsequently, my lord, there's a order passed, and then the challenge before the District Council. The District Council dismissed, upheld the Maulum Ramkadai as a village and recognized as a village. Then they came to the High Court in the year 2010 itself, my lord. They came to the High Court and the High Court dismissed their petition filed by the respondent number 4. And then they went for writ appeal in the year 2012. Then the High Court, Honorable High Court, Dishonorable High Court, has passed an order dated 26 of 2014, remanded back the matter to the District Council to decide on one issue, whether the change of name was done as per the Administration of Ilaka Act 1991. So in the year 2015, the District Council set aside, upheld the appointment of respondent number 4 as Sardar of Maulum Ginyong and recognize the village as Maulum Ginyong. And in the year 2017, the then Sardar of Maulum Ramkanai filed a review petition. This council then again recognized Maulum Ramkanai as a village. Then, my lord, in the year 2017 itself, the respondent number 4 filed again a writ petition before this honorable court, and this honorable court held that the district council has no power to review its own order. That means the order passed in 2015 was upheld. Thereafter, my lord, the issue here is with regard to the name of the village, because Maulum Ramkanai has been.
So if your petition has been dismissed, I mean, and no review lies, what happened? What's the remedy after that?
My lord, what we want, the villages as a whole, we want that the name of Maulum Ramkanai should retain. And we have filed many representation before the.
No, but if that issue is already over, or it's only with regard to election of Sardar that's
Yes.
over, what was decided in the earlier proceedings? Where you said that the district council ruled against you.
Yes, ma'am.
Then a review for you.
Yes.
Then that matter came before this court, and it was held that executive
So
committee is the
subsequently,
power.
my lord, we want to go as per the procedure of the Ilaka Act 1991.
No, but if it's already decided matter, how do you want to re-agitate it?
Because, my lord, many schemes have come in.
No,
the
no,
name
forget
of the
about the
village.
schemes. How do you want to re-agitate it? If your village now goes by what name? It goes by Maulum Ningyong.
Yes, ma'am.
Then your Ramkanai is gone.
No, my lord, we want to retain Maulum Ramkanai
No,
because
but
till date,
but
my
if
lord,
you see,
all the
but if
schemes-
you say that issue has already been decided,
Yes,
correct?
ma'am. Yes, ma'am.
And then the name of Maulum Ningyong has been upheld by the district council. On review, maybe they decided, but that has also been set aside by this court, correct? So your name will remain Maulum Ningyong, correct?
Yes, ma'am.
Then what remains for you now?
Because till 2021, my lord, till 2021, the name of Maulum Ramkanai survived.
Yes, Mr. Kinta.
I don't, in fact, I couldn't understand the matter. I'll take instruction, Your Lordship. It appears that the writ petition is directed against the respondent number 3, Sim of Mariam.
Okay, let's issue notice.
My lord, if you can come,
Clear the air.
my lord, if you can come to the order passed by this court, my lord.
Yes. Which page?
Next 3, my lord, page 30.
Page 30.
Yes, ma'am.
The last order.
Last.
Yes.
Learned counsel for the petitioner submits that the issue involved in the writ petition stands resolved by the order dated 17 January 2022 passed by the Executive Committee, respondent number 1. The only grievances that he has is the time given to the respondent number 3 and 4 to hold the election to call for the Dorbar is too long, and as such pray that he may be allowed to move a application before the Executive Committee with regards to the time limit given by the order for the praise that the matter may be closed with submission. Here the order 14 January 2022, next page 28. Here the Executive Committee, page 29. The Executive Committee felt that the villagers have the right to ask the Sardar to organize call for the meeting when they need to discuss matter within the village. Therefore, the Executive Committee is pleased to direct the Sardar of Maulum Ginyong village to organize call for a meeting as per the customary practice.
That was not done.
No, madam.
Okay, yes, you heard that, Mr. Kanta. Let's issue notice then. Heard Mr.
Yes.
Asad, that is the counsel of the petitioner. Issue notice to internable in 4 weeks. Mr. Vijay Kanta with so-and-so, except notice on behalf of 1, 2, and 3. And notice to go to spot number 3 and 4 by the said AD within 3 days. This is thereafter on so-and-so. For instructions.
I'm 1 and 2, Your Lordship.
Yes.
I'm 1 and 2.
1 and 2, yes.
Obliged.
Much obliged. Good day, Your Lordship.
Item number 2.
My lord,
Yes.
My Lord, petitioner herein, my Lord, is challenging the notification.
Who's the petitioner?
My Lord, petitioners are the chairman, assistant secretary, and members of the Sunrise Ilaka Rimbai, my Lord. Now, they are the one, my Lord, who are challenging the notification dated 19th April 2023, whereby the executive committee, my Lord, returning officer, Dolorship election, he has issued a notification, respondent number 3, issued a notification for election of Doloy, my Lord. Now, in the notification, my Lord, this notification has been published without putting the criteria that the candidates will be applying for this post, my Lord. They have to belong to 3 particular clan, my Lord, and also they have to be from the indigenous Niyam faith, my Lord. Now, that is as per the law, my Lord, which has been laid down by the Honorable Supreme Court in the case of Iwan Lanki Rimbai case, my Lord. Now,
Mr. Dr. Mohan, can I take up this matter since that case had appeared before the High Court and Supreme Court also, on which he's relying upon?
Right. And this is in consonance with their act, my Lord. That is Jaintia Hills
I understand.
Yes.
But this case, Mr. Sinkon, I think you're aware that I was the counsel before the division bench, before the Court, High Court, and also the Supreme Court, where it was successful, whatever case we pleaded there. And you're seeking full reliance on the judgment itself.
Right, my Lord.
So is it correct if I take up the matter, or what to do?
My Lord, that is a judgment, my Lord, which has been given by the Honorable Supreme Court, my Lord. That is the law laid down by the Honorable Supreme Court. That is bound by any other court also, my Lord. That is binding on everybody, my Lord. Now, my only grievance is, my Lord.
We understand that, yes, that same thing, temporal and other duties. And the only thing is that.
But the notification doesn't say anything, my Lord.
Notification is blank. No, notification is that what he's saying, there are 2 points. Firstly is that usually in customary elections there are certain clans which are eligible, that is silent. And number 2 is where should he come from, whether he to perform the rights or this and that. When is elections?
My Lord, that election is
on 24th.
On 24th
of May.
So already nominations have already been filed.
Has been filed. In similar such cases, my Lord, the Honorable this court, my Lord, has suspended the election, my Lord. I have relied one of the order.
Who is this? Because election is going to be held on one day. You take instructions, Dr. Mozika. We'll have it on when Mr. Shulai will have it on. Now is 16th. We'll have it on 19th.
Only, my Lord, I will be absent for a week, my Lord. If my Lord can only suspend for the time being, my Lord, this.
We'll have it elections on 26th.
Yes.
This next week. So we'll have you be here. We get conveyance, but day after tomorrow.
Monday I can.
Monday will take too long, see, because day after tomorrow.
My Lord, I'll be absent, my Lord. I'll not be here.
You get some other counsel to come to your place.
If I can appear. My Lord, in the meantime, if I can pray, my Lord, only the order dated, my Lord, notification may kindly be stayed, my Lord. This has been even in earlier occasions, my Lord, the similar cases, my Lord, this was suspended, my Lord.
See, in this earlier case,
what we want is, my Lord,
elections like tomorrow. You understand? There's some finality to it.
Yes.
That's why this court, I think, had stated at that time is the election we shall held tomorrow. Shall be suspended for
vital questions has to be decided.
But let them come instructions.
Yes, that is what. Only for the time being, my Lord.
Before that, then we don't need to pass
only for the time being, my Lord, so that there is no.
They'll come to instructions day after tomorrow.
By Friday.
By Friday, yes. There's a matter on Friday to enable the heard Mr. N. Sinkon, the counsel of the petitioner, issue notice. Dr. N. Mozika, you appearing for response number. Firstly,
who is district council, madam? 2 and 3.
With
Two.
Mr. So-and-so, issue notice. Mr. N.D. Shulai, Leonard AAG with so-and-so is present and accept notice on behalf of number 1. Dr. N. Mozika with MS Rumthau, present accept notice on behalf of 2 and 3. No further notice called for. Stop. The matter appears to be urgent in as much as elections to the post of Dollar of
My lord, Ilaka Rimbaman.
Mumbai Eleka are scheduled to be held on 26 5 2023, and the process already underway. Stop. The main,
My lord, voting will be on 24th.
The main contention of the writ petitioners are that the notification whereby elections have been called are silent several aspects as to the clans eligible and also the faith to which the candidates should profess or belong to. So next paragraph, that view the matter, learned senior counsel Dr. Mozika is directed to obtain instructions by the after tomorrow. List the matter on 19th Friday for further orders.
The voting is on 24th.
24th.
It's scheduled for voting on 24th.
Main list item number 2.
Yes, Mr. Demran.
You see, in this case, they are obstructing this petitioner obstructing the works.
Who's obstructing?
Petitioners.
What about the matter pending for division bench?
So, you see, in this matter, I don't know anything, but this I got the intimation, you see, when they went for the works in 4th, and then there is.
I think we making wrong submission. The matter, last orders as a matter pending for division bench, yet to be disposed. This is matter on 16/5 to its outcome.
So, Illusive, in this case, this is a division bench if matter is pending, any other matter similar situated. In this case, Illusive, in my miscellaneous application in 88, who has passed the order to go ahead with the work. So,
where to do work?
This NHDCL.
Where's
So, Illusive, in this case.
None of your other counsels are present. Where's Mr.
Your Lordship, I have received instruction that one of the petitioner in this matter is going to file writ petition before the division bench.
You're going to file?
It's going to file.
Going to file what?
Filing a petition before division bench. So I'm praying that this matter may come after 2 weeks.
In this case, Illusive, on 4/5/2023, the petitioner obstructed not two works there. And
4/5/23. Where exactly did it obstruct the work?
So, Illusive, and after this, on 12/5/2023, department intimate to the deputy commissioner.
Where's that letter?
So, Illusive, letter I am not having them, but
then how we make submissions in the air only? How we know whether it's correct or not?
This I sent my WhatsApp, but I was not in a position to print get me.
It's on WhatsApp.
Yes, I was not in a position to print out because it is not working. So I got this intimation.
Oh, I don't want to see your phones. All right, you can keep it back in the pocket. As a senior
they are violating this order.
Senior counsel, we have a petitioners absent. This is a matter of 2 weeks. Stop. Next paragraph, it will be reported by Mr. R. Debnath, though no document has been produced. It has been, huh? Huh? It is what? Hotel. So next one, the MS also based with MS E Wanyang. MS E Wanyang, learned counsel for the petitioner. But is that the matter be taken up after 2 weeks due to the absence of,
2 weeks.
One second, due to the absence of the senior arguing counsel, the senior counsel. Stop. Next, Mr. R. Debnath submits that in connection with the incident matter, the respondent authorities have been obstructed from continuing with the work. Stop. Though no documentary proof has been brought on record. Stop. What else you have to say?
So, Illusive, there is a clear violation of this order of this honorable court.
Which is a clear violation of the orders of this court. So, next paragraph. What about you all?
Pleadings are already concluded.
Yes, sir. In view the absence of the senior counsel, this is not 2 weeks. Yes.
So, instead of 2 weeks, Illusive, as because works is going to be affected, Illusive. So let the matters, whether they are violating or not, these matters to be examined.
This is not 2 weeks. Petition to obtain instructions as to whether any obstruction has been caused to the ongoing project. Yes.
Item number 3.
Yes.
Yes, Your Lordship.
Case where government and teachers of Sav Shiksha Abhiyan, they were
Yes.
negotiating, my lord, and they have reached on some sort of settlement, my lord, whereby government has agreed to pay the back wages for period from 1st July 2016 to 28th February 2017, my lord. And
Where's Mr. Qureshi?
Your Lordship is not present today.
I know he's not present. What kind of answer is that? You're standing here means because he's not present, correct? Is that an answer to give to the court? He's not present today. Yes. What do you have to say? Do you have any instructions?
Your Lordship, I've got instruction that the settlement talk has been going on, Your Lordship.
We'll close it then. You're not interested.
yes, sir.
We'll accept this. You know that the submission advocate general is like an affidavit.
No, I have a letter, my lord. I will place that later
Where's the
also.
letter?
My colleague will. Yes, letter is here. Next page, page 2 now.
One second, see the prayer here.
Prayer is, my lord, for release of salary for that period only.
You're wanting from. You say that 8 months first, July 2016.
28 February 2017, my lord.
Where we said that you're going to pay that?
Your lordship will see the letter. Letter says, my lord, this is the total areas, and your lordship will find the first installment they will get in June 2023 of amount of 1191.615 lakh. Then they will get second installment in December, my lord. Then balance is this, and this is how this 2383 have been divided in 4 installments, my lord.
You gave him a copy. Tell Mr. Qureshi to be present tomorrow. Yes, the Letter Advocate General has produced a copy of a communication dated 4th April 2023, whereby the formula for release of pending arrears salaries of SSC teachers has been indicated. Copy is handed over to the council, who's there to obtain instructions. This is the matter tomorrow on supplementary list. Copy of the communication is taken on board and be part of the report. Yes. Don't see. You're a junior, so when it's not an answer to give. Say for some reasons. No need to apologize. You all have to learn that way. Yes.
Item number 4.
Matter.
Right.
There is an earlier order on 23rd February 2023 where they make a statement that BS has been directed to investigate the various issues regarding this pending petition, and they said that the report will be submitted to the Ministry of Home Affairs. That one is still awaiting, Lordship.
But these matters, my lord, there's a bunch of matters. Inquiry is being conducted, my lord. That was the.
Okay, from February. Now, what happened to inquiry?
My lord, after that, I'm awaiting some update on that, my lord.
Your Lordship.
Yes, Mr.
Yeah,
Paske.
Lordship. Actually, we were there. We participated in the inquiry as well. We are also waiting for the report.
Okay. Who else participated in inquiry? You did participate? Still participated.
We're not aware. We were just informed that inquiry will be conducted by the union.
No, of course, by union. I mean, you took part.
No, I'm not aware.
You took part, Mr. Sama.
No, Lordship.
You didn't take part. Why?
Only department, petitioner is not invited, I think.
Oh, you're the National Highway Development Authority.
NBC.
Okay.
National Building.
National Building. Okay. It has been submitted that the inquiry, which is being gone into by the BSF, is yet to culminate. Is over or is still going on?
It's still going on.
But it appears it's still going on, my lord.
Mr.
There are many
It's
aspects.
still going on, Your Lordship.
Still going on. Yes.
It's going on.
Then we'll just record that it is reported by the counsel with the parties that inquiry is still the inquiry which is being conducted by the BSF is still underway. Stop. In that view, the matter, this is a matter after 6 weeks to await any outcomes.
If this honorable court may be pleased to direct the BSF to issue notice to the state also for the purpose of the inquiry.
It is understood that the state and other stakeholders, no need, the state should be also made aware of the proceedings, stage of proceedings. Yes.
There are several cases which are tagged together. It was over to 12 in the order column. Item number 21.
No, 14 also. 14,
21, 31, 33.
Just give the number to the court master.
Yes, we'll give the number.
13.
Yes.
Deeply obliged.
Yes.
Your Lordship, we'll file the affidavit in the course of the Your Lordship.
The rejoinder?
Yes, Your Lordship.
You are Mr.
Ikastir, Your Lordship.
Mr. Ikastir for the petitioner submits that the rejoinder will file in the course of the day. This thereafter on so.
18. 18. 18.
My lord, if I may interrupt, 15 is also separate matter. It is not connected with the other matters. The contempt matter is a different matter. 15 will be a different matter, my lord.
15
Those connected matter earlier that my senior has appeared, it's still item number 14, my lord. So 15 is,
I'm not getting it.
my lord, those matters, those Indo-Bangla, that matter was taken up. It will be till 14. So 15 should be called now, my lord.
Oh,
Not
15.
18.
Call 15.
15.
My lord, we have come to a settlement.
1 second.
Yeah, you've already part of that. You have signed it.
Yes.
My lord, if lordship permit, my lord, all the payment amount as in which the contempt has been made, my lord, has been already concluded. Now the status of the case, we have made excess payment. So they have to return that, my lord, which they have not disputed.
My lord, is that since those aspects could not be gone into the contempt, we'll withdraw it, my lord. Let them
However, my lord, it may be reflected, my lord, my prayer is the petitioner should return. I have the copy
That
in
cannot
which
be
they have
given in
participated.
contempt, my lord, because at the stage of the writ petition, they have never said that.
My lord, he is
After
good. My
filing
lord,
the contempt,
his
they
prayer
say
was
that
to.
there's a mismatch of the amount.
So you've kept the excess amount.
that is
He
How
kept
much
it,
excess
my lord.
amount?
He very much kept it, and
How
he
much?
concealed. My lord, it will be around 75, my lord, lakhs.
75 lakhs?
Yes, my lord. My lord, I have a copy of the meeting which his representative has signed. He has also agreed to return the money. So if there's maybe
we are
bigger
not
party.
saying that we'll not return. What I'm only saying is we'll withdraw the contempt. And
No, you can't withdraw the contempt, Mr.
It will be
Mr.
closed, my
Mr.
lord.
Deb. It's not in your hand to withdraw the contempt.
My lord, because they have substantially complied, but to give
Yes,
a
okay.
direction to
Fully
refund,
complied, my lord. We have
Yes,
for the bill. It is a substantial.
It is not. Submissions have been made at the bar that.
My lord, I have a copy of the
contempt
meeting,
does
my
not
lord, in which the
survive
petition-
any longer, in as much as the writ petitioner has been paid all the outstanding dues.
they have complied. That is the only.
Yes,
My
they
lord, we have
complied,
already
yes.
paid. I have a copy, my lord,
Stop.
can have it.
Next paragraph.
His representative have
However,
participated.
MS Alkolni has apprised this court that not only has the order been complied, but an excess amount has been paid to the writ petitioner. Stop. Next paragraph. This court in contempt jurisdiction is only concerned with the factum of compliance, violation and compliance. In that view, the matter has nothing survives consideration. The contempt matter is closed. Any other collateral proceeding, the parties are at liberty to pursue. The matter stands closed because of this.
Highly obliged, lordship.
16.
My lord, 16 and 17, my lord, notices have been served. I believe the learned counsel has entered appearance today for the respondent.
Today?
Well, do you file Vokaltam?
Yes, sir. Dr. Mozika.
This is a matter where SLP is pending. My lord. A bunch of matters.
Has entered appearance on behalf of the respondents today. As such, service is complete. Pray for and allowed 4 weeks time to file affidavits. Yes.
18.
Please, Lordship. But you are not able to settle, Your Lordship, give me 1 week's time for let it go for hearing, Lordship, because I will do the.
What's the settlement about?
Because this is regarding the dispute, but I'm the second wife. Is Mr. Sey appear report the first wife. So first wife and second wife they are claiming and for the pension, and then other service benefit that is still yet to be withdrawn with the government with the office of the MECA department. So that is a case, Lordship. So I have filed the second. The petitioner here is the daughter and the second wife of the deceased, Lordship.
Petitioner here is the
second wife.
There are two petitioners.
Okay, petitioner is one is Joropina Marak, she is a wife.
It's a daughter.
Oh, daughter. And number 2 is the wife.
Second wife.
And Purmali Marak is the.
They claiming her to say that to be a first wife.
Whose marriage is registered? None.
My one. My one, and I am
When were you
getting.
married to?
I was getting the pension, Lordship.
When were you married to the deceased employee?
2010, Lordship.
Your name's in the service book?
Yes, service book. Pension, I was drawing the pension, Lordship.
He's a policeman?
No, MECA, Lordship.
Okay,
Subsequently, my friend has filed the case with a prayer that we stop my pensionary benefits. It has already been released, and I was getting the pension.
That's what happened actually.
Now are you getting or you stopped?
Because of the order, Lordship.
Where's the order?
Now matter was heard at length. When the matter was heard, the court was about to.
My lord, on the 10th of August, 10th of August. So,
10th of August? This has been so long, this matter. How can it be pending for so long? 10th of August.
There is an interim order, my lord, that the corporation in which the deceased employee, my lord, the pension was directed. We were directed not to release the pension until it's decided who is the actual pension.
Okay.
Actually, the the respondent get this one because he obtained the illegal death certificate from the.
Can a death certificate be illegal?
Illegal, Lordship, because this is died in the Barapani only. But in the Barapani, this Umiam Lake, he was staying there, Peter. And then that death certificate is still yet to be obtained from the proper PHC from Barapani.
You mean the death certificate was obtained from Bangmara? Is that the case?
That is not the case.
That first
That is not the case.
No,
what is right?
One second. Let him finish. Where's the death certificate?
Death certificate was. It was Lordship. To that we find the FIR also, Lordship. The FIR is still going on. This is the death certificate, Annexure 19, not Annexure, Annexure 6, page 19, Lordship. This reflected death certificate of the disease.
Well, that means that he died in Calcutta.
Yes, Calcutta.
Well, that's why it was a stay order.
Yes, Lordship. Because this is the fact death certificate. We have this, and we have to that effect we filed the FIR also. And the correct death certificate is still pending with the Umiam Lake. It has a PHC, Primary Health Center in Umiam Lake. And that person died in that Umiam only, and he was buried there only. But the death certificate was obtained from the Calcutta. So that's the case.
Yes, Mr. Sheikh, how did that happen?
My lord, kindly come to my page.
Have you filed affidavit?
Yes, Lordship.
Yes.
There is no dispute. Page 11, Lordship. This is the pension payment order of the pensioner, Lordship.
1 second. Page 11, yes.
Joint photo, including my photo, Lordship, is pasted there. This is the pension payment order to the pensioner, Lordship, my deceased husband, while he was in alive.
That is whatever
Now,
may be, but we are
below
not
down.
denying. Lordship.
Where's the marriage certificate?
Marriage certificate, Lordship. That is at page 7, Lordship.
So you were married on
2010, Lordship.
2010?
Yes, Lordship.
He died on?
Died on 2021, Lordship.
That means you're the second wife.
I am the first wife, Lordship. Then subsequently, Lordship.
Then how did he have? How old is the daughter? How is your petitioner here?
The daughter, of course, is already more than 10, but the wife, second wife is there, Lordship.
She is 30, more than 30 plus, Lordship.
The daughter?
Daughter. And wife.
You're the first wife?
Yes, Lordship.
And he married in 2010?
10. Then, my lord.
And then he's got a daughter from his second wife, 30 years old. How is that possible?
I am disputing. Because what he is saying that daughter from the
petitioner.
Not from the daughter from the first wife, Lordship. Then I will be second wife and she will be the third wife.
Not like that.
If
Lordship, let it come for the detailed hearing, Lordship, because after 1 week I will prepare everything.
No, but if that's the story, then she's been deprived of pension now.
Yes, because this what happened is like this. Because of course the second wife, the petitioner, she don't have the marriage certificate. But is this the fact that they have been living together?
No, I don't care about that fact. How? No, just explain. If the person entered a service book, married in 2010, correct?
Lordship. Even we are disputing that.
Okay, fine.
That certificate also is the fact. It can, because how can he marry only on 2010? The children already more than 35 years, which is impossible.
No, this court also fails to understand that.
And moreover, they have obtained the fact death certificate is they are not disputing. Person died in the Barapani, and he obtained the death certificate from Garo Hills, and the body is there lying in the Barapani, and the PSC health center have not issued the death certificate to both parties. They are asking you go to the court and get the court order and get the proper death certificate.
My lord, para 2 of his writ petition,
That
my lord. He has stated,
but the
my
main
lord.
thing is he's not answering.
Let's see, what is your right?
There are 2 of who are the petitioners and the respondents, Lordship.
Oh, I understand. You're saying that he had another wife before.
Wife before. That is his.
Before you also.
Before me also, he has got.
And he's another wife.
Another wife. Seems to be another third wife also. We don't know, but the person who is claiming that only she is the one. Then the daughter Jiprina.
Now,
there are
So
three
the three claimants, that means.
But one is not claiming. There is not coming before this court.
Who's that?
The petitioner number 1.
But you said that petitioner was legal daughter of the first wife who died.
Yes.
How is he come before court? She's dead.
It seems to be his let me get
See, Mr. Sabha, you absolutely managed to confuse the court completely.
Lordship, I will get the proper instruction.
What instructions do you get? Now, what have you written here in the para 2?
That is what I will instruct.
What kind of see, petitioner one legal daughter of so and so from first legal wife,
yes.
so and so, and number married father present petitioner number 1, remarried present petitioner number 2, so and so, how private petitioner number 2 have deserted, abandoned, children living separated for 20 years.
Yes.
How can live 20 years when they married 2010 only?
And I have got 3 children, Lordship, from 2000.
That's why we said even that marriage certificate is not proper one, because they have been living without marriage only.
I have enclosed 3 birth certificates
So
of these children, Lordship.
as per this petitioner number 2, Jiprina is the daughter of the first wife only. Then where the mother.
Most confusing and convoluted facts here. Now that means that the petition number 1 is not your daughter, not the daughter of petition number 2.
No. Not.
How you're living as a family? Then you say here.
No, they're living even now also they're living together in the Barapani only. Where the died.
It's for orders for hearing.
It is order for
This matter for hearing in the usual course. But see, the thing is that They've been deprived of the pension, and they're recorded in the. Should we let them have the pension now?
Yes, Lordship.
That's why this court's hearing just now, at least because your pension has been stopped and your case is not doesn't seem to be here or there.
Because it's not like that, because they also don't have the proper.
Doesn't matter. They have at least the papers and the service records, the name of the respondent number.
In fact, is that they have even obtained the death certificate.
That's irrelevant, Lordship.
Very unfortunate.
19.
Much less, Lordship.
Hello.
Lordship, the private respondent yet to file the affidavit, Lordship. They have been asking time.
Good translation.
What?
Finish.
Lordship, we have sent for signatures, so Lordship, can you wait for 2 more weeks?
Yes, Kiriam.
Yes,
Mr. S can please not 2 weeks further time to file affidavit. Yes.
Obliged.
20.
We fix it for hearing.
MS Adatta.
2 more matters are listed today, 53 and 54.
Today?
Yes.
Listed for hearing?
350.
Come listed together with them.
Yes, MS Adatta submits that the pleadings are complete and that the matter be placed maybe posted for hearing stopped. According to this matter for hearing, it is reported that it is also submitted that
WPC
2 other
420
connected matters, namely
53 and 54.
that the
WPC 420 and 430 minute.
420.
420 and 430.
420, 430 on a similar issue are pending for this court. This all the 3 matters together. You are appearing other matters also.
My Lord, on item 54, WPC 430, we are appearing.
What about the other one?
Mrs. Badua is in. PTU Badua.
Yeah, list matters together for hearing after 4 weeks.
In these 2 matters, the
Interim orders, if any, shall continue until interim orders, if any, shall continue till further orders.
22. 22.
Respondent, I get to file affidavit.
Lordship, I pray for 2 weeks' time, Lordship, to file the affidavit.
Your Lordship, I'm appearing for.
22 matter.
Yes, Lordship.
3.
3.
Why didn't appear last time?
Lordship, I wasn't aware. Lordship. I apologize.
You filed your affidavit. You already filed it.
Yes, Your Lordship.
No, you already filed affidavit.
No, I'm not aware of the briefs of the past.
Praying time, Your Lordship.
I'll pay for time to file my affidavit.
Respondents pray for now further 2 weeks time to file affidavit. List thereafter.
23.
This is the matter relating to the annual mela held at that property in Mahendraganj.
Oh, yes.
I was directed to file an affidavit by Lordship's order dated 10th. We filed it, we've supplied a copy. There were 2 issues. One, judicial orders that may have some bearing on this case. And number 2, any material to show that I had any semblance of right in performance of any of these melas. May I just
open the case of the petitioner here?
Lordship.
So this is a case in respect of a shrine.
Yes.
Which the petitioner was said it is a it is a WAF property registered as a WAF before the Meghalaya Court of Law. So, my lord, the law says that if the question arises as to whether a particular property is a WAF or not, that matter should be decided by the WAF tribunal under Section 6 of the WAF Act. And Section 83 provides for constitution of the WAF tribunal. So when the suit was filed by the respondent hearing claiming herself to be the owner, first the Khadim had, which is the caretaker, had filed the suit. During the pendency he died, then his widow came and claimed that it is a personal property. So against that, instead of filing a written statement, it appears the petitioner has submitted an application to the court stating that it is a WAF property, therefore this court has no jurisdiction. This issue should be decided by the WAF tribunal. On the basis of the application, the trial court dismissed the suit. Being agreed, the respondent comes to High Court, but the High Court in the year 2000 came to a conclusion that no, the same court has the jurisdiction to try the suit, and it was remanded back, and status quo was maintained. Status quo means when the suit was filed in the year 97, an injunction order was granted restraining the petitioner me from entering into the suit property. So that status quo continued in 2000 also. High Court said status quo to be maintained. Thereafter again the suit procedure, my lord. And in that suit, written statement was filed as it ought to have been, and issues were framed whether it is of property or not. Finally, after hearing the parties, the trial court dismissed the suit on the ground that as it is work property, the court has no jurisdiction in the year 2004, my lord. So after the suit was dismissed, then naturally the status quo does not remain anymore. It is gone.
That is 2004.
2004, my lord. So in 2004, the petitioners approached the Deputy Commissioner for taking possession of the shrine. And accordingly, the DC issued a letter to the police and others, and he was restored to possession, my lord. Before 2004, as my learned friend has indicated in the affidavit, several times the respondents conveyed the mila, because it is a fact that from 97 to 2004, it is she who was in possession of the property. So she got the permission, there is no dispute. And after 2004, my lord, when I was restored to possession, and that restoration order is there, filed by my learned friend, it is in page 89 of the affidavit. Well, I will be reading from type copy because that is not very visible. Please. In 2004, it is an order passed by the Deputy Commissioner of Garo Hills, addressed to the Additional Deputy Commissioner in charge Ampati Civil Subdivision, and subject is pertaining to Pir Kamal Dargah Sharif at Mahendraganj and annual fair thereof.
Yes.
Madam, with reference to the subject cited above, I am to inform you of the following aspects pertaining to the Pir Kamal Dargah Sharif. A title suit was filed in the court in the subdivision office at Dadangari, which had been decided upon by an impugn order upon which the Honorable Guwahati High Court in Civil Division number 10/2000 held. The impugn order dated 28/3/2000 passed by the learned subdivision magistrate Civil Subdivision Tura Court, West Garhwal District, passed in title suit 197 is set aside, thus remanding the case to the competent court of the assistant to the Deputy Commissioner of West Garhwal District Tura for disposal of it in accordance with law. It is made clear that the learned trial court shall dispose of the case as early as possible within a period of 6 months from the date of receipt of this order in accordance with law, after giving reasonable opportunity being heard to the parties concerned, and in the meantime the status quo with regards to the suit property as on today shall be maintained till appropriate order is passed by the learned court below. So my lord, it speaks about the High Court's order which was passed on 28/3/2000, that within 6 months it should be disposed of. Thereafter, my lord, paragraph 2. Accordingly, the matter was endorsed to the court of the aforesaid to the Deputy Commissioner Tura, whereupon the title suit number 497, white order dated 15/4/2004, the court of Sri C.N. Sangmai MCS has held that the title suit does not stand for want of jurisdiction, and relevant suit property, that is the Shah Kamal Dargah, is a work property under the meaning of section 3(4) sub rule 2 of the Waqf Act 1995 and not a private property. While later dated 27/4/2004, Mr. C. My Lord, on 15/4/2004, the suit was dismissed on the ground that it is work property. So on 15/4/2004, there remained no injunction and no question of status quo as on date, my lord. So when that order was passed,
yes,
then while later dated 27/4/2004, Shri Cesar Ghafoor, IPS retired, Chairman Meghalaya Board of Waqf, has indicated to the office of the undersigned to assist in recovery of the property and handing it over to Muhammad Abdullah Mia, which is a present petitioner, the board's appointed Khadim caretaker. Number 4, Sri S. Nagru, Honorable Minister of Communication, dated 27/4/2004, has directed the Khadim Muhammad Abdullah Mia to approach to the office of the undersigned. Given the above legal position of the Shah Kamal Dargah being that of the work property and duly appointed Khadim by the Meghalaya Board of Waqf being Muhammad Abdullah Mia, it is pertinent to inform your office of the following. A. Pertaining to the application to conduct Mela by Srimati Jasra Beva from the office of the undersigned, while later dated 16/3/2004, no permission granted but instruction issued to deal the matter at the level of SDO Civil Ampati. B. Annual fair Mela to be held on 2nd of May and 9th May shall be held in the premises of the Dargah under the caretakership of Muhammad Abdullah Mia. Accordingly, the situation to be reviewed at your end and necessary steps taken with the assistance of the administration machinery at your disposal to hand over the caretakership of the state work property to Muhammad Abdullah Mia.
So you mean there was a definitive, conclusive finding that this dargah was Waqf property?
In that order.
In that order, that means evidence had been gone into as to where the Waqf Nama existed, everything.
No, my lord, the defect
It's a shrine.
is, and I'm not on the whether it is the right order or
No,
not.
no, I mean, no, but what
no
findings
evidence
arrived at?
actually
What
evidence
findings
was-
arrived at that
Yes.
this dargah is a
Waqf
what,
property.
and
No
so
evidence was-
then the suit was dismissed.
Only it was hard.
Now what happened after that?
So after it was dismissed, so there appeared a vacuum. In that vacuum, the Meghalaya
You were
board-
given permission
yes, permission to hold Mela, and also position was handed over to me, my lord,
of the dargah.
of the dargah in the year 2004. Thereafter, my lord, I continued to hold Mela every year, and it is recorded in the impugn order passed by the learned Ahmadi magistrate. I have already annexed the impugn order. That from there in the year 2004 till date, up to 23, I had been holding the Mela. And it is in the context of that this order was passed, but the learned assistant deputy commissioner, without following the procedure, laid down section.
No, the thing is that if that suit was dismissed, what is the pending suit now?
Same thing was restored in the year.
How was it restored?
By the High Court. Being
Where-
aggrieved, but they
In
were
the year
aggrieved by
2000.
the order of dismissal.
Order of dismissal is 2004, 15/4, 2004, correct?
Yes.
Yeah, what happened after that? So after the dismissal, you took over the shrine.
Yes. But in
As
the
a Khadim, you
dismissal
were-
order was challenged by them in the High Court.
They challenged it, they were not restored to
No
possession.
such order was passed from 2004 till date, despite the fact that the High Court passed an order remanding back the case to them, to the assistant deputy commissioner, and staying the orders impugned therein. So this means the civil suit was restored. But in the meantime, this order remains. And neither the Honorable High Court nor the assistant deputy commissioner.
Which order remains?
Yes, my lord.
Which order you said remains?
This order by the deputy commissioner. Giving me the
2004.
ownership. Sorry, of the position of the property, my lord. That order is at page 70, my lord. I have just read it. So page 89 of my.
Where's the order of the High Court?
The High Court order is my lord.
And whereby the suit was again revived and
It is, my lord, it starts from page 43 to page 47. Its type copy is at page 49, my lord, dated 31/5/2004.
this is page 44.
Yes, page 44, but its type copy is at page 49.
Page
49. Dated 31/5/2004, my lord.
Okay.
So here it says that title suit number 4 of 97 was instituted.
Okay, this is what I just go on to know.
Yes, 31/5/2004. So let us read, my lord, only the last paragraph that is relevant here. In view of the above position, I am of the opinion that the impugn order dated 10/3/4, 12/4/4 and 15/4/2004 passed by the learned assistant deputy commissioner cannot stand in the eye of the law, and accordingly the same are set aside and quashed. The matter is remanded back to the learned trial court to try the same in accordance with law, and thereafter they decide the issues framed by the court as per the procedures laid down by law. The learned assistant deputy commissioner shall try the case from the stage of its stand on 10/3/2004. My lord, the thing was that on 10/3/2004, no issues were framed, no evidence was taken. Therefore, the High Court directed them that you first prepare the issue, frame the issue, and record the evidence, and then come to finding. So this 10/3/2004 does not mean that the status quo was given to anyone. And even if it could not have been given, because in the meantime, Deputy Commissioner has put me in position. So that position was never placed before the High Court, my lord. Had they placed that matter, then this order would not have come. So, in any event, this order of 10/3/2004 cannot be said to be status quo position of 10/3/2004. It only means that you proceed from there, frame issues, record evidence, and pass the necessary orders.
Yes, we an appeal then after that.
Yes, the appeal by appeal upheld the civil bench order. Thereafter, it went to Supreme Court, and Supreme Court also dismissed the petition. So, therefore, the position is that the suit should be remanded back to the Assistant Deputy Commissioner, who will try the suit according to law. So,
what's the stage of the suit now?
Suit till date, my lord, no evidence recorded. Because from 2004 to 2011, it traveled from one court to another up to Supreme Court. It's about 7 years ago. And after 2011, I don't know what happened till date.
No, after Supreme Court last was disposed upon.
2011.
Yes.
2011 at page number 62, my lord.
Yes, you've seen this on Annexure 12.
Yes, so especially petition is dismissed. And it was dismissed on 9/9.
Yes.
8/11/2011. So from there it came back to Assistant Deputy Commissioner Ampati, and still the evidence is to be recorded. This fact is yet to be ascertained as to who is the real owner or real caretaker of the property. So now, for the purpose of this petition, which I have filed, my lord, the Deputy Commissioner had granted the permission for holding the Mela for last about 18 years. It continued, my lord. In the light of that, it was given, and in the meantime, there is no order by any court restraining me from holding the Mela or restraining me from controlling the shrine, in view of the order passed by the Deputy Commissioner.
Now, in this intervening years, did they ever object to holding the Mela?
They might have objected to the Deputy Commissioner, but Deputy Commissioner has held that as there is no intervening order.
Did they object or not?
They had objected.
I mean, every time when the Mela, when you sought for permission.
2-3 times they have objected, and they also wanted to hold the Mela, but the DC said how it can be done because there is no order passed by any other court restraining the petition.
And the fact remains that you are in possession of Dargah now.
Yes, till date.
You are running the
Yes.
the
For
affairs
last
of
18
Dargah.
to 19 years, I am controlling the Dargah and I am holding the Mela.
Is that a fact, Mr. Sen?
And the impeachment order, in the impeachment order, all those dates have been given. Date of the permission where I am holding the Mela.
Yes.
For all the 18 years. And so, therefore, the petition under Section 51 is not maintainable, my lord, when the DC is not a party there. At least Section 80 says that no order, interim or otherwise, can be passed against the state government, against the government, without following the procedure laid down there.
No, but I think the suit, there are no official respondents.
No, this is not the respondent. So, how could the order be passed? Interim or otherwise, no order can be passed against the DC.
Yes, Mr. Sen.
Please, Your Lordship. But one of the questions was what was the status of the property prior to the suit being filed? Kindly turn to page 14 of my affidavit.
No, we're not there anymore. We just that because I've understood the suit was proceeding is stuck.
I'll just show Lordships how the property has changed hands.
Where?
Page 14.
Yes.
So kindly see, this is a letter, order dated 16th April 1998. This is issued by the district magistrate to the respondent's deceased husband. At this point, he was alive, and he was given the permission to hold the dargah. Now, at the moment, we have this permission only from 98, and another permission, I apologize, my lords, at page 12 as well, is a permission from 1983.
No, but this is all prior to the filing of the suit.
I'm just showing Lordships how the property changes. So 83 onwards.
I don't dispute any of this thing. Whatever he said, I don't dispute. It was there up to.
Just for my satisfaction, my lord. Just take Lordships very quickly.
Not
so
for the court
83
satisfaction.
onwards, my lords.
Not for the court satisfaction. For your own satisfaction. Fine.
No, Lordships have already gone through it. Yeah. So from 83 to 98, there is no dispute, as my learned seniors put it. Then this is the time when the suit was filed in 1997. So during the pendency of the suit, he was still being granted the permissions to hold the Mela. Now thereafter, can you come to page 1818? This is another first round of litigation before the Honorable High Court. Now certain orders were passed, and there was some sort of an injunction order in favor of the plaintiff then, which was also vacated. Questioning that, they approached this Honorable Court. One of the issues was that the order was to be passed by the Court of the Assistant to the Deputy Commissioner. Instead, it was seized off and passed by the Subdivisional Magistrate. Therefore, the Magistrate did not have powers, and it was set aside. If Lordship will kindly have page 19 is the relevant part of the order.
Yes.
I just read, my lords. The impugned order dated 28/3/2000 passed by the learned Subdivisional Magistrate Dadingri Civil Subdivision at Tura Court, West Garhwal District, Tura, passed in title suit number so and so is set aside, thus remanding the case to the competent court, that is the Assistant to the Deputy Commissioner West Garo Hills, District Tura, for disposal of it in accordance with law. It is made clear that the learned trial court shall dispose of the case as early as possible within a period of 6 months from the date of receipt of this order in accordance with law, after giving reasonable opportunity of being heard to the parties concerned. And kindly note this, my lords. In the meantime, the status quo with regard to the suit property as on today shall be maintained till appropriate order is passed by the learned court below in the matter. For the reasons aforesaid and the directions made above, this petition is disposed of, and so on. So there was a status quo order passed by the Honorable High Court. Following this, the parties went back to the learned trial court, and even in the meantime, Lordships will find at page 22, permissions were still being granted in favor of the respondent. By this time, her husband expired at page 22. She stood substituted at page 22. This is the permission from the 21st of April 1999 in the name of the respondent. Lordships will then also find permissions of the year 2000, 2001. At page 25 is the permission from the year 2000.
Well, that's well and good. What
so all of this was there.
Saying that from 2004 onwards, they have been consistently holding the Mela. That's
point out how that has happened.
No, even we're not going to go into that here.
No,
we're going to go to the status of permission, what kind of permission is giving, and where it vests any rights on you, or whether by virtue of permission, like it might create, your claim to title, any good claim for good title. If that doesn't think, then we will.
I'll be brief, my lords. So till 2004, Lordships have noticed permissions being granted in our favor. Till 2003. In 2004, after the written statement was filed, the court framed about 7 issues. One of the issues was whether the property is a WAF property. And the court came to a conclusion the property was a WAF property. Court did not have jurisdiction and dismissed the case. This is at page 41. Order dated 15th.
The entire proceedings all died. Okay.
All died.
Right.
So court holds there is no jurisdiction.
Yes.
And then I'll just skip a few pages and take Lordships to what happened immediately after this. So on the strength of this order of 15/4/2004, the petitioner appears to have applied to the magistrate. My learned senior had referred to a particular order dated 28th April 2004. The typed copy has been supplied to Lordships.
Yes.
So here Lordships will find the DC's ground for granting this letter is threefold. One, that the suit has been rejected and the trial court has observed there is a WAF property. Number 2, they've received 2 letters, one from the WAF property and one from a minister. So on the influence by these 3 findings, these 3 factors, this permission was granted. Now I'll just take Lordships back to what happened. The matter travelled to the single bench of this honourable court. It was disposed of. The court held that there was no evidence before the learned trial court to come to the conclusion that this was a WAF property. Now, being aggrieved, the petitioner moved an intra-court appeal. That was disposed of by an order dated 9/9/2008. Now, this order is relevant. I'll just try and persuade Lordships why this order is relevant. Kindly have page 56.
Yes.
Para 5 minutes. At the outset, it may not be out of place to refer to the findings recorded by the trial court while dismissing the suit. It appears from the order dismissing the suit that the trial court was swayed by the fact that the appellant herein had produced a copy of the list of WAF estates recognized by the Meghalaya Board of WAF and that the suit property had been listed in the said list as WAF property estate. The trial court also took into consideration the order dated 8/4/97 issued by the Chief Executive Officer Meghalaya Board of WAF appointing the respondent number 1 as Khadim of the Shah Kamal Aulia WAF estate, Mahendraganj, to look after the Mazar Sharif. The trial court also had observed that the appellant herein could not produce a single supporting document to prove that the suit property is otherwise a private property. It was on the basis of those findings that the trial court held that the suit property is a WAF property within the meaning of section 3 of the Act and not a private property in view of the provisions of section 7 of the Act, and that the suit was thus not maintainable for want of jurisdiction. In our considered view, the aforesaid findings were considered in light of the admission made by Mr. A. Siddiqui, the learned counsel for the appellant, in the course of hearing this appeal, that the list of WAF has not been published by the Meghalaya Board of WAF under section 5(2) of the Act appears to be perverse. The procedures for publication of the list of WAFs under section 5(2) of the Act are laid down in section 4, starting with the exercise of preliminary survey of WAFs by the Survey Commissioner of WAFs appointed by the state government. If no publication in respect of the list of WAFs was done, as is the case here, the Meghalaya Board of WAF has the statutory duty to register every WAF, whether created before or after the commencement of the Act, the procedures whereof are laid down in subsection 2 to 8 of section 37. There is no evidence at this stage to conclude that this exercise has been undertaken by the board. No evidence has been produced by the appellant to show prima facie that the suit property has been registered as WAF property under section 36. The so-called list of WAF properties produced by the appellant before the trial court is neither one published under section 52 nor one appearing in the register of WAFs maintained by the board under section 37 of the Act, which in turn is to be based upon the registration of WAFs made in accordance with section 36 of the Act. Therefore, we have no hesitation to say at this stage that suit property is not a WAF property. There were certain typographical errors, like here Lordship will find it says suit property is a WAF property. These were subsequently corrected in the review proceedings. So, my lords, the court conclusively holds that this is not a WAF property. And this is not a minor observation, my lords, because there was no procedure followed under section 37.
But there are things that the suit is still pending.
Yes, my lord. So, what happened? Now the suit stood restored, and what came back into operation of the Honorable High Court's order of 2000, whereas status quo was in operation.
Where is that?
Well, it was the status quo which I just referred to, which is at page 18. Justice Lamare's order, my lords. When the suit stood dismissed, all orders went. When the suit stands restored, all orders come back. It restores back to the original point, my lords. That is my humble submission.
Where's
that order is at page 18, my lords. 18.
Well, that's not Justice Lamare's order.
Yes, lordships. I apologize. Justice N.S. Singh's order.
That is, you see, the thing is that was dated when? 18 is dated when?
9/5/2000.
2000 is later proceedings are.
So in 9/5/2000, the Honorable High Court directs that till disposal there should be a status quo.
That will not go there, because that order of Justice Singh, I think we will disregard, because there's a subsequent proceeding which came before a single bench again, went again before the division bench, went up to the Supreme Court.
And I'll point out what happened.
That's the thing. So we can't mix up those orders now. Whatever happened is that it was remanded back at the relevant point of time or frame 7 issues. Then after that, the matter was taken up and it was dismissed. In 2004, correct?
Yes.
And then after that, it came again for this court. So how can you say that it goes back, it rewinds itself?
What I'm saying is that
because there were certain orders after that. Like 2004 is the main order now that survives, for which you had come up against, correct?
Yes, well.
Yes.
So my understanding is, Manoj, when there is a status quo order by the
we're not going to go into splitting hairs. The thing is that the fact remains, we will go into the permission. And what does it decide that whether it's a WAF property or not, whether permission, or whether does it give just a simple permission to hold a mela for the benefit of the public, and it does not vest any title, or it'll not give the petitioner any leverage into say that that this permission is given and so the property is private or it's walk off or whatever. That's the only thing. Yes.
So, my lords, what I understand, 2004, when the suit stand dismissed on the observation it's a WAF property, they apply
now
for
that
permission.
you have to make those. Now, where's the impugn order? Where is the order impugn? Let's see what the Assembly Deputy Commissioner said. And what's this 2019 order?
My lord, Annexure 7 is the impugn order passed by the learned Assistant Deputy Commissioner Ampati.
Page
38 of my petition, my lord.
What's the operative part?
And my lord, at page 32.
Why is this order wrong?
Because
we know operative part. Okay, we know why order is wrong. Yes.
So just 2 more facts. May I just place just 2 more facts. So after these proceedings were held, the property changed hands. They started obtaining permissions, and then thereafter.
So why at a point of time? Why at a point of time no operative application was filed before the trial court? If you say that status quo had been restored by the High Court orders.
No, they have filed. They have filed.
No orders are passed there.
They were dismissed, I believe. She does not, because she, as far as she's concerned,
again against that.
Lordship, I'm not sure why they did not pursue it.
Okay, anyway.
Page 66 have enclosed. They filed an application. They filed repeated objections before the DC. For some reason or the other, these were not pursued. Now, in 2022, they had again applied for permission for the Mela to be held in the month of March. For some reason, it was not held. We are not really sure why. They then rescheduled the Mela to be held in the month of November.
Of 22?
Yes. So we went and filed an objection. Just a moment. If Lordships will kindly have page 84
of
my affidavit. So March the Mela is not held, and it turns out that
I like this. Why? Because the civil petition is 10 pages. And the affidavit runs to 100 pages. So bring on record materials.
Of 25 years.
And turns out this is not everything.
Page 80.
Page 84. 84. An extra 20.
Yes.
So we find out that since it's not held in March, the petitioner proposes to schedule it in the month of November. So we file an objection, and the DC responds to our objection in this fashion, my lords. It reads, I am to refer to your application dated 7th November 2022 and to inform you that the undersigned has granted permission for Dargah Mela at Pirpal Shah Kamal, so-and-so, Mahendraganj, after following due procedures and based on views and comments of the SP West Garhwal Sampati. The SP Southwest Garhwal Sampati has conducted inquiry and found that there is no any interim order or any instruction from the honorable courts to prohibit the holding of the Dargah Fair Mela at the Pirpal Shah Kamal Dargah Sharif, Mahendraganj, and recommended accordingly. And they say, so therefore the permissions which are granted in favor of the petitioner cannot be cancelled or revoked. So as a result, now what we are left with is to go back to the court and obtain an order. As a result, we filed an application under 151. And on the basis of that, the courts allowed it. Now kindly see the objection that they filed before the trial court. That is at page 85.
No, see, the thing is that, see, Mr. Sen, coming round circle again, we are not sitting here, to go into the competing rights of, whether it's a property, whether it's private property, whether, who has invested him with the power of Khadim, nothing of that sort. What we're going to do is only to the legality of the order and your challenge to it. And by going by the precedent, if from 2004 you've been holding without any incident, then what prevents? What prevents them from holding that time? Then, meanwhile, let them hold a Mela and then you take your remedies to the civil court or whatever.
So
I order unsustainable without the orders issued by the deputy commissioner.
My lord. No, so I did approach the deputy commissioner. He says get an order from the civil court.
Yes.
So I did approach the civil court under 151.
Did you approach civil court?
No, my lords. He says that there is no order from the civil court granting any sort of stay order. So what that basically means is that I need to go to the civil court.
What does the civil court say?
The civil court's order
page 34.
Is at page 30.
Yes. What's the operative part?
So the civil court refers to all the orders. If Lordships have page 35.
Okay.
35 onwards. The trial court takes into consideration all these orders. One, at para 13, Lordships will find the appeal which was before the Honorable Supreme Court. Thereafter, at para 14, the counsel for the petitioner asserts that the order dated 31/5/2004, passed by the learned single judge, Guwahati High Court, and so holds a stand that the defendant, and so on.
Yes.
And then finally,
this correct finding is. You assert that yes, now you are asserting that 2000 should come into play, but now by your own submission, he said counsel petitioner asserts the order passed by thing holds the field.
Yes, my lords.
Yes,
the fact that the observations of the trial court that this is a wharf property does not stand, and the petitioner in 2004 sought to change hands of the property by asserting that particular order of the trial court. That order of the trial court does not stand today. In fact, the division bench of this honorable court has made it very clear that it is not a wharf property. And those were not just prima facie observations, those were in detail.
Well, that should be taken up again by the trial court.
Now, let's just see what has happened. So, we are sitting with the trial court trying to take up the matter. I'd refer to those impleadment applications which were filed by some interlopers. Now, what's happened? Kindly have my affidavit, the last document that I'll take Lordship.
No, just finish this order of the Assistant Deputy Commissioner. What is the operative part?
Kindly have page para 17 at page 36.
Para 16 first.
Para 16. It is on record that the permissions obtained by the respondent to hold the Dargah Mela in the premises will not be permissible, and the same will be an abuse of the process of the court, as the same is reflected in the judgment and order dated 31/5/2004, passed in WBC so-and-so, wherein the Honorable Court held the impugned order dated 15/4/2004.
Yes.
15/4/2004 was apparently passed without any evidence on record and without considering the issues as framed by the court, without any evidence referring to the evidence of it being a wharf property.
Yes.
In view of the above position, I am of the opinion that the impugned orders dated 10/3/2004, 12/4/2004 and 15/4/2004 passed by the learned assistant to the Deputy Commissioner cannot stand in the eye of law, and accordingly the same are set aside. The matter is remanded back to the learned trial court to try the same in accordance with law and thereafter to decide the issues framed by the court as per procedures laid down by law. The learned assistant to DC shall try the same at the stage as it stands on 10/3/2004. Hence, in view of the judgment and order passed by the Honorable Judge in WPC so-and-so, I do not hesitate to say that the permission obtained by the respondent to hold the Dargah Mela in the premises of so-and-so ceases and is to be stayed pending disposal of the suit. It is also observed in review petition number so-and-so that the suit property is not a WAF property. Even though the defendant Abdullah SK preferred a writ appeal before the Honorable Division Bench of the
Now,
Guwahati
one thing, okay, fine. One thing is that now that means it's come to conclusive findings on WAF property. That means one issue of the suit has already been settled.
That is what I understand, Manoj, also.
Yeah, how can it be done?
Why I'm saying is because they had asserted it's a WAF
how can
property.
it be done?
On
Now,
the basis,
where there's discussion on the permission about what the permissions, what are the recitals in the permission?
Lordship, I believe
there's nothing.
that. Lordship.
It's totally blank. As what type of permission is granted, whether it's connection to whether they'll use it in perpetuity or whether it vests them with any rights. Nothing is there.
Lordship.
That you cannot deny. I think because it goes into a history which need not be gone into.
So, Lordship, just kindly consider. From 83, I've shown there are documents to show and they don't dispute it.
We're not going to get caught in the same jam that this poor assembly negotiator got caught in, that are going and starting, narrating the entire,
Lordship. So the property change hands on the basis of an order which does not exist has been set aside. Now that has not been undone till today.
Right.
During the pendency of the suit, just because an order, certain observations were passed which were incorrect, the property could not have changed hands. And who passed this order? The DC. Now we are asking the DC to undo it. The DC refuses to undo it. He says get an order from the civil court. At the point when the DC handed over possession,
then that your recourse is not to civil court any further.
And so they themselves say get an order from the court. So therefore we felt fit to file an application before the court to get an order. And once we have the order, they say that, and Manoj, on the basis of the order, they've complied with it. Now just one last document, Manoj. Can you have my affidavit?
No, pass an open court better. Yes. Still have time. Yes.
Just two documents, page 108 and 109. 108, following the passing of the impugned order by the learned trial court, the DC has passed this order dated 4th May 2023.
Yes, no, that is
This is one. And kindly see, this year, with the object of delaying the suit even further,
where?
The petitioner at page 109.
Yes.
Now, what is going to happen? My suit is going to go on for another 10 years.
We'll not allow that.
Kindly say page 109. They file a miscase number 1 of 23.
We'll not allow that, Mr. Sen. They will have to do course correction.
Lordship,
just see that this permission is become totally a sidelight to the main dispute. It's a sidelight. And the main thing is that the main thing is just boiling. Nothing has come out of it. So the thing is that it's good. It's come now by way of this revision. Then we can pass.
And repeatedly, courts have directed that they've issued a timeline for the courts to abide by. They have not been abided by for whatever reasons. Now they file at the fag end of the case. The case is fixed on the 1st of June. They file an application on the 15th of April 23 for amendment. And kindly see what is the amendment they're seeking at para 2, that the suit is not maintainable under law and fact, and that the suit is not maintainable under the Meghalaya Land and Revenue Regulation as well as under the Specific Relief Act. This they want to cause in their written statement at the fag end of the case. The intention is very clear. If it is refused, they'll come back before some appellate court and obtain some sort of a stay. The case will keep dragging. Now, my rights have to be protected in some way.
Of course.
Property has changed. And what I am also instructed, they derive up to 2 to 3 lakhs per bela.
No, that is, see, the whole thing boils down to that. If whoever gets to hold the mela gets, it's very lucrative.
Let whatever revenue is generated be placed before the court and let the case be disposed of within 6 months.
Only run the mela.
At least some. This will provide the necessary impetus.
You will deposit?
No, my God. So that's within 6 months it should be disposed of. How in this petition order can we give it like that?
That could just come 5 minutes. We'll pass, we'll dictate order. 5 minutes.
Lodge.
That's the whole bone of contention. Một phong nào, thọ phi là bị thật, cái nhỏ phim này. Where's the petition? This revision application under Article 227 of the Constitution of India has been preferred against the order dated 28/4/2023 passed by the Assistant to Deputy Commissioner (J) Southwest Garo Hills in misapplication number 13 of 2023 arising out of title suit number 4 of 1997. The matter in issue in the present revision application concerns the grant of permission by the Deputy Commissioner, Southwest Garo Hills District, Ampati, to the petitioner for holding of a Dargah fair, DRGH fair, at the Pirpal, PIRPAL, Shah Kamal, Shah, separate word, Kamal, separate, Dargah Sharif, Mahinderganj, Southwest Garo Hills, on 30th March 2023, as per the terms and conditions mentioned therein. Stop. Next paragraph. Relevant facts needed for consideration of instant revision application is that this Dargah, that is Dargah also, is presently under litigation in, what's the title suit number? TS number 4997, which is pending before the Assistant Deputy Commissioner, Southwest Garo Hills, between the petitioner, who is stated to be the Khadim, KHDIM, and the respondent. Stop. The history of litigation, as narrated in the application, and also the facts brought on record by the respondent, show that the right to control, as also the title, of the Dargah Sharif by the parties herein has been in serious contention since the institution of the suit. Stop. the dispute mainly with whether the said property is a war property has also traveled to this court in not less than 2 occasions and also before the Honorable Supreme Court. So, wherein successive orders have been passed directing for expeditious disposal of the suit, but which, however, for reasons unknown, remained at the stage, as reported by the parties, remain at the evidence stage, as reported by the parties. It is relevant to note that the tussle it's also relevant to note that a tussle also exists with regard to the rights of the respective parties to organize and hold the annual Dargah fair. Stop. It has been paragraph. Stop. Next paragraph. From the materials placed on record, for the materials placed before this court, both the petitioner and the respondent have been at pains, PINS, to show that at certain points of time, permissions have been granted to either of them to conduct the said Dargah fair in the suit premises. Stop. From the side of the petitioner, at para 6 of the petition, it is noted perusal of para 6 of the petition reflects that the petitioner has been granted permissions to hold the annual fair, Dargah fair, from 2004 consistently till 2022, and it's only on the intervention of the respondent that the court below has prohibited the same till disposal of the suit. The respondent, on the other hand, as projected in the on the other hand, it is seen, had also You were held. How many times you did the Mela?
From 83 till 2003.
That's correct.
Yes, my lordship.
Yes, sir. The respondent on the hand.
Not from 83, time immemorial till
Yes,
2003.
The respondent, on the other hand, in the same had also.
The respondent on the other hand. Not the seat. On the other hand, it appears had also conducted the Mela from 83 till
83 is one of the documents till 2003, but way before it.
Had conducted the Mela till 83.
Till 2003 minutes.
Till 2003.
From which point I'm not really sure.
Till 2003, yes. Stop. Next paragraph. The learned court below, sorry. On an application under section 151 of the CPC, in the pending suit, thereafter, after issuance of notice to the petitioner, I'm not the respondent. Sorry.
On an application under section 151 of the CPC in the
Filed by the respondent.
After issuance of notice.
After notice to the petitioner herein, taking Tom, sorry.
On an application under section 151 of the CPC in the pending suit filed by the respondent after issuance of notice to the petitioner herein.
Then, where's the part? Where's that part which says until supposed to suit? Oh, yes.
The learned court below on an application under section 151 of the CPC in the pending suit filed by the respondent after issuance of notice to the petitioner herein.
Then by placing reliance on an interpretation of judgment and order passed by this court in WPC number 131 bracket SI 2004, annul the said permission and state the same that in supposed to suit. Stop. Stop. Next paragraph. The only question that is to be decided in the present proceeding, in the considered view of this court, is with the legality of the order passed by the legality to impugn order. And as to whether the same was without jurisdiction or illegal, that needs correction by this court in a proceeding under Article 227 of the Constitution. Stop. In this context, the order dated 30th March 2023, issued by the Deputy Commissioner South West Garo Hills Ampati needs to be examined as to whether the grant of such permission to hold the Dargah fair has in any manner affected the existing rights of the respondent, or whether you are the plaintiff, correct? Whether by the said permission the respondent bracket plaintiff has been non-suited in the pending suit. Stop. In the considered view of the court, it should be new next paragraph. After disposal to next paragraph. Okay. A perusal of the permission dated 30th March 2023 indicates that a permission, the permission to hold a
Perusal of the permission dated 30th 3,023 indicates that.
no, not indicates that perusal shows that certain terms and conditions have been stipulated therein, by which the convener or any other person interested was to abide by. The convener or organizers. Stop. It is relevant to note that in clause 2 of the said permission itself, it has been clearly provided that, clearly stipulated that the permission, I will in single inverted commas, on a double, that's a double, it will clear that permission in bold anymore. Permission should not be used by the organizers to present their claims over disputed property in any court of law, close inverted commas. Stop. The import and purport of the permission, therefore, limits the purport of the permission, therefore limits the is strictly confined to the holding of the Dargah fair, and moreover the clause as quoted above, it is to be noted, has consciously been inserted by the Deputy Commissioner, being well aware about the pending dispute, over a pending dispute before the civil court. So, that's what it was. The civil court, while examining the matter, without considering the contents of the permission. However, proceeded in an exercise into the entire history of the litigation. Which would have surely involved a more thorough discussion as to the life of the orders that have been passed by the courts earlier, and as to their enforceability. Stop. The order, admittedly, is an order passed in executive capacity by the Deputy Commissioner, and is not a it is not a proceeding that is emanating from the main title suit. Stop. No materials have been placed for this court also to show that this particular fact had ever come up for consideration before the civil court seized with the suit. Stop. We'll not go into other materials. Next paragraph. Though other materials have been, though other facts and materials have been placed for this court at this stage by the respondent, especially in support of her case, this court, for the limited purposes of adjudicating the instant matter and the legality of the order impugned herein, deems not necessary to venture into those aspects. Stop. Next part. The order being irregular and without jurisdiction, inasmuch as, apart from not vesting any rights or creating any third-party rights, has been passed without considering the nature of the same, the fact that it was an order passed in executive capacity of the Deputy Commissioner. Stop. Next paragraph. This court, however, notes with concern the fact that the suit has been pending how many years now?
97 or so.
25 almost. 25.
26 years. 25.
For over 25 years. And justice demands that the same be disposed of. Which it appears, in spite of repeated orders, have not been occasioned. Stop. In this view of the matter, next paragraph, you deposit 50% of the proceeds.
Something should be.
No, because I am under the board, I am to pay the 7% of the collection to the board. Why not?
To the?
Because he is a khadim under the board. As per the Waqf Act, whatever income comes in work property, 7% of the same is to be deposited with work property. That will not be.
Well, the division bench is very categorically held it's not a work property based on not just the materials before the suit but other materials.
We're not going there. We're just letting the people enjoy the fair. That's all. I'm not giving directions that at least for this time. The thing is that the way the order was is seized. I mean, isn't a executive order. It's not a you can say it's not even 144 order. It's not even that you have recourse to other remedy also.
That may be indicated that I'll make a representation before the DC. I may be permitted to make a representation before the DC. At least that minimum order should be given.
No, but we're looking into the past permission 2004 even running it. And that's the thing.
No, but we have been categorically applying to the DC. We have been applying. Now, for what reason she could not pursue? Because I've also made a statement. She's a domestic help, drawing a salary of 1,200 rupees per month. What means can she possibly have?
Well, give her some money.
They have got a mobile shop.
What that's run by the son?
The son is grown up, so all they are living together, son and mother.
That's barely anything.
For mother 1,200 and the son is coming 12,000.
No, I don't think that's good. Not 12,000. Barely anything.
So such as a formula, how much will you deposit?
So let us say about 30% you will deposit.
30% deposit of the
50 is fair.
No,
50
is
fair.
not fair.
There'll be necessary
because
impetus and motivation to participate in the suit.
Don't say that the proceeds of entire Mela was only 1,000 rupees.
No,
when it comes to the
it's in lakhs.
50 lakhs.
It's in lakhs.
In such a jungle, it is lakhs.
No, it's in lakhs.
What is the attendance like?
Few hundred only from the locality.
Mahendraganj, few hundred. I know those areas, Mr. Siddiqui.
Few hundred. Thousands people cannot come in.
Even a bazaar, you can't even stick your foot in. We go to
This court, however, notes with concern the fact that the suit has been pending for over 25 years and justice demands that the same be disposed of, which it appears in spite of repeated orders has not been occasion. In this matter.
Yes, I'll pass the other orders then.
And may also, lastly, criminals, since they've also filed an application for amendment of the WS, this will just linger on. Some sort of an order.
Yes, no, we'll take orders. That's only this time. That is why I'll just frame the properly that, with regard to the suit. Yes.
I'll leave this.
24. 24.
They said that it is still process, but in fact, one of the affidavit indicate it has been done only after filing of the contempt petition. In the page 11 of that, they have indicated they have started some process petition of
process for this is hearing.
Regularization and pensionary benefit. Because there was an order to complete the whole process and pay the pensionary.
Within how long?
But now it's been more than 6-7 months. Also.
Now I am coming to the page number 9, my lord, in my affidavit. How the delay was.
Page number.
Page 9, my lord.
See, one thing I keep on repeating, Mr. P.T. Sangma, is that you see, contempt means clear violation. That people don't care for court order. When the people are scampering to try and comply, you come to contempt after just 1 month. Suppose you say 4 months. When 4 months and 1 week, you're filing contempt.
Lordship, that's okay. But sometimes Lordship,
that's okay.
Lordship, my submission is sometimes Lordship, the officials sometimes they don't care because they take advantage.
It is
no one. I don't think in Meghalaya that there's any willful violation. There's no willful violation or blatant. It's only procedural. Procedural. What do you call it? These delays and processes are there always.
But Lordship, whatever is happening, they should communicate to the petitioner or others affected person so that this person may not come to the court also if there is any communication.
Why are you making them come to the court then?
Because there is no any communication regarding their processing. That they're saying that they have started.
Why we've written? Where you show us?
Page number 9, my lord, annex 1. So matter will be clear for my account. Shall I read out my?
Yes.
Subject regularization of
yes.
works as service rendered by.
Well, close it, Mr. You've seen this. You've seen the affidavit.
Yes.
Then. Seen the affidavit filed by the respondent. So, wherein letter dated 14 March 23 is enclosed, indicating that the
only 7 months, my lord.
That government approval has been accorded for realization of the work charge service rendered by the petitioner. As such, nothing further survives consideration in the petition and seen disposed of.
Actually, it's just make
Your own interest.
As expeditious because sometimes
They've already given it.
Initial pay
You
statement
filed another
also already
contempt.
completed, my lord. They
Yes.
wait within
25.
Master Lordship.
Your Lordship, I have received a affidavit, Your Lordship. I'm praying for 2 weeks time to file rejoinder, Your Lordship.
Rejoined to what?
To the affidavit, Your Lordship.
You rejoined or not?
Yes.
You rejoined.
About the contempt, Your Lordship, I have no idea, Your Lordship.
Where's the other matter?
Lordship, this is
The same one. This is the same.
Yes,
Where's the
same,
content?
Lordship.
Item 1 is that
Item?
Item number 1, Your Lordship. Yes. Your Lordship, what-
First, you come to this one. Yes, but D. Nyota submits that doesn't wish nothing says of contempt as the writ petitioner has since rejoined.
I actually have no idea, Your Lordship, whether she has.
You asked to take instructions from 10:30 till now.
Your Lordship, I have no idea, Your Lordship.
Where's your senior? You say you showed to your senior.
Lordship, the seal is there, Lordship, but
You've signed it. Is this your signature?
Yes, Your Lordship. This is the joining report. Your
Is this a
Lordship.
signature?
Yes, Your Lordship.
Then
well, this was on 5th May 2000 of this month, of this year, Lordship.
But I was not allowed, Your Lordship, to join in that day, Your Lordship. And on the 8th, she came here, Your Lordship, for signature to file this contempt. So after filing this contempt, Your Lordship, I have no idea whether she is allowed to join or not, Your Lordship.
she was not allowed to join on 5th also.
No, Your Lordship. That's
You
why
take
she came
instruction.
on the 8th, she came.
You take instructions. Ada kan number?
Item number 1.
Item number 1 of regular list. This is matter after 1 week. And this one in this matter, this is number 1 contempt case. This matter after 1 week to enable the petitioner to obtain instructions. And this matter now is Mr. D. Nyota please funds allowed to send for rejoin the affiliates. Just
Right.
thereafter.
26.
Lordship.
You've examined the case?
Yes, I have examined the case, Your Lordship. I've seen it right from Supreme Court and everything. Now, when I look at the judgment and my first prayer in the first place.
17/8/2022, 189 is covered by that case.
No, because my first prayer in my petition itself is that I want my score sheet, because they said that I'm tainted. So I said, please show me the score sheet. I want to see the score sheet. It is only after I see the score sheet that I don't know whether I'm done, that whether what they're saying it's true.
No, one thing, Mr. Varjari, the general orders have been passed and all these matters will apply to you also.
Yes, sir.
So I think submission of the AAG is that since this, this matter has been again taken up and this order dated 17/8/2022.
Lordship, in that order, para 21, Lordship, if I may read it. It says like this: this court is also inclined to accept the submission of the respondent that there exists distinct causes of action and...
1 second.
Yes, yes.
Para
21. It says here, yes.
Mr. Shulai, the one he gave me is missing this page. This
Yes,
is
Your Lordship, this is the judgment.
Yes, I know the judgment, but then is the one from 17 to 20 is not there. I know. Kindly give the correct copy.
Lordship, I have kept 2 copies. One is judgment passed by Lordship. Another one is by the division bench, Your Lordship.
Oh, sorry, Your Lordship. It's
21, Your Lordship.
Yes.
Yes, sir. May I read it? This
Yes.
court is also inclined to accept the submission of the respondents that there exist distinct causes of action and clubbing of the petitioner in one petition, and further seeking to make a distinction of 46 petitioners who are each barred from the total of 66 petitioners without indicating the names of those petitioners has surely disabled the writ petition. So
Yes.
this is the writ petition that they have filed, which is the culmination of this judgment. First of all, it's a disabled one because the distinct cause of action.
It's just that the age part ones were taken different. See what happened. The lawyer did not press the other for the first petitioners. He pressed only for
Yes. So my case is it's what I want.
See, and you read the next paragraph.
Yes.
Read 22.
Yes.
Read 22.
As observed earlier, there is nothing left for consideration by this court, as all the issues have already been discussed and dealt with. To reconcile the matter on the pleadings of the writ petitioners herein would therefore amount to going behind the orders of the division bench, which is impermissible, as the liberty to so granted to the petitioners is circumscribed by the order dated 2/11/2017 and 22nd/9/2020 passed in with appeal number so and so and with petition number so and so. Yes, Lordship. So, Your Lordship, if you, my prayer here in this the first prayer only, just the first prayer, I want to know my score sheet. Now this, I don't think so. I'm barred by this judgment to even get my score sheet.
You're beating a dead horse to make him run. How would that serve any purpose?
Yes, Lordship. Now because what from this
this order was appealed against also, I believe.
Lordship, I have given also the.
No, I don't have it here.
Writ appeal number 39/22, Your Lordship. In fact, on the last occasion, I keep both the order, Your Lordship.
Your Lordship, I am not even a party in this case also, in the first place.
Doesn't matter. It's a general principle of law. It'll apply to all the people similarly situated. So even if you're not a party, you come, you go through the same grind and get the same order. Just so another thing. You also agree with the reassessment exercise, correct?
Yes.
Yes.
Because the assessment as it is was how I became dated is after the CBI report. They say that I'm.
That's why after CBI there was reassessment. Yes. So
But the
anyway, what to do?
The assessment, they said that the 2 marks that I got is how did I get it? Now if you go to this the selection committee, they already have a procedure. Second division 5 marks, third division they get 2 marks. Now that third division 2 marks is from here. That is prior to the CBI. Now let's
go to your prayer, okay?
Yes.
Let's go to your prayer. Are you saying like my prayer is different, right? Now the only thing that to bring on record actual score sheet, you want reconsideration representation of the petitioner, you want to quash impugn 3-member committee report, to quash the impugn termination order, reinstate back the petitioner to service. How is that possible? You're climbing a steep hill, I know that, very difficult in view of the many judgments. And we are bound by the other judgments, that's the thing also. That's called judicial discipline.
Because my representation also was decided last year.
Yes. Thing is that
the last
now the thing is that you do not get a score sheet because set also the CBI. What do they say?
CBI, Your Lordship. Being seized by the CBI.
Yeah, that's
you don't have the record with
they
us.
don't have the record.
So what are you going to do?
In CBI also they don't have it. When I approach CBI, the CBI also says they don't have it.
What to do this matter, Mr. Chulai?
Lordship, in my humble and respectful submission, Your Lordship, it's it's absolutely covered by judgment passed by Your Lordship. Because in that indirect petition, Lordship will kindly see they have challenged their report dated 22nd February 2021. So also in the here in the petition also, Your Lordship, if Lordship is pleased to come to the prayer, Your Lordship, quash the impugned 3-member committee report dated 14/5/2022 and also 29/6/2020, Your Lordship. She is concerned with the petition hearing is concerned with 14/5/2022, Your Lordship. It's the same finding, Your Lordship, by the committee constituted under the direction passed by this on court in Bruce Reed appeal.
What to do, Mr. Varjari?
Lordship, clear finding of this honorable court is para 20 of the judgment, Your Lordship.
Of the judgment?
Your Lordship, yes. The judgment passed by Your Lordship at para 20. In the considered view of this court, Lordship has quoted. Lordship will permit me to read. With the grant of the liberty and the subsequent proceeding before
With age relaxation. Your case is what? Age relaxation?
No, Your Lordship. Here is she has been wrongly given the extra mark, Your Lordship, to which she is not entitled.
Let him live to fight another day. We'll file affidavit. Just file a small affidavit. Yes.
Lordship.
Respond. Though
Come for weeks.
Though arguments have been raised that the no cause of action survives as these instant matters covered by earlier judgment of this court, Mr. Varjari prays that the matter be given due hearing in consideration thereof. Response to file a brief affidavit. This matter after 4 weeks.
Obliged.
Yes.
27.
We're still in orders.
For affidavit has to be done.
The voluntary retirement. Dr. N. Mozikal and DSG praise sponsor for the 3 weeks time to file affidavit.
Hearing supplementary list. Item 3.
Mr. Jindal, what is the urgency in this matter you're pressing for hearing? I thought what's the urgency?
In fact, there is no urgency.
Urgency, Lordship, is there.
You see, I was thinking on hindsight because I accepted your submission, your prayer of upgrading, thinking that there was some, there was a serious threat, that they've been driven out of employment.
No, not in that manner, Your Lordship, because.
So these are, their rights will be decided, of course. Their whatever rights they have, but then you said that it's very urgent that this matter be taken up. So I was under the impression that yes, that this Mr. Jindal's clients are on the edge of the cliff, about to be kicked out from there.
No,
but when I heard the matter that day, there's nothing. It's only going back to 2012.
Your Lordship.
2012.
All of a sudden they wake up, Your Lordship. 11 years.
No, you listen, let him say. That's the thing. Can you finish in half an hour?
Yes, Lordship, since we have already advanced quite a lot, and Your Lordship will be pleased enough to give me an opportunity.
No, I'm not saying I'm denying opportunity, but just that. See, the upgradation of matters happens when I would not mind hearing pension matters, this matters, or this this impending termination.
Yes,
those are urgent, but then
this is urgent in the larger view, Your Lordship.
How can a larger view be urgent?
No, Lordship will just.
Yes, continue. Yes, start.
Yes, Lordship. There are two issues
which I have conversed in this, which I am conversing in this petition. One relates to regularization, and regularization here means the conferment of the permanent status to the employees. And second one, I am conversing before Your Honor that Lordship, the equal pay for equal work. Both these issues are distinct issues, Your Lordship. One doesn't depend upon the other, Your Lordship.
Well, I remember correctly now, your case on the basis that since they are secretariat employees, they are governed by a different recruitment rules. Correct?
Yes.
And whatever recruitment that has to be gone into has to be as the rules which, vest them or give them some rights.
Yes, Lordship.
To apart from regular employees.
And
the only thing, but only that goes against you, only thing
if,
goes against you is the advertisement.
No, I'm coming to that.
Yes.
I'm coming to that. Your Lordship will turn to the advertisement.
Yes.
Before I turn to the advertisement, Your Lordship, there is no denial of the fact that the posts in questions are sanctioned posts. There is no denial of this fact. On this parameter, I read this advertisement.
Yes.
Application.
Page?
Page 29, Your Lordship. Applications are invited from the citizen of India as defined in Article 5 to 8 of the Constitution of India for temporary engagement as peon in Meghalaya Civil Secretariat, Shillong, on payment of daily wages at the rate fixed by the state government under the Minimum Wages Act. So Your Lordship will find the temporary is qualified with the word engagement. Now it doesn't qualify with the categories of post. It is whether the posts are permanent posts, regular posts, or what type of post is not specified in the advertisement. It only, the temporary engagement here is the nature of appointment and not the nature of posts. This is one aspect of the matter, that there is nothing mentioned that the posts are temporary or regular. They make this advertisement. Then Your Lordship will come to, we'll also see that first appointment is at Annexure 3, page 37. Page 37. Page 37. Page 37. The following persons are appointed as casual peons. Is Lordship got it?
Yes.
Casual peons in Meghalaya Civil Secretariat for a period of 1 year from the date of appointment on a fixed remunerations of rupees 4,000 per month. Your Lordship will notice here, the advertisement was for temporary engagement without specifying the period for which the temporary engagements are to be given. Now, the department first appointment letter they issues for a specific period of 1 year, that is on the that it is a contract for the period of 1 year. You are appointed for from the date of appointment on a fixed remuneration of rupees 4,000 per month. Your Lordship will notice also here that even the nature of the appointment which was advertised is not followed in the first appointment. Now, if it is a contractual appointment for a period of 1 year, then your lordship, my question is, where is that contract agreement? If there is a contractual appointment, there has to be some contract agreement on the basis of which this appointment letter was issued, which is not coming forth from the department. Now, after 1 year of the expiry, these peoples are treated as if they are permanent, as if permanent. Temporary engagement, your lordship, cannot be for a period of 10 to 12 years, your lordship. It has a limitation.
Yes.
It cannot continue for a indefinite period, your lordship. Your lordship will further notice the subsequent appointments which are made from the select list, which is at page 39 onward. It says that the following persons are appointed as casual peon in Meghalaya Civil Secretariat on a fixed remuneration of rupees 4,000 only per month, with effect from the date of joining until further order. This is again a deviation from the advertisement. Now, your lordship, my submission is this, that the advertisement have been that of temporary engagement, but the methodology which is followed by the department is that of the recruitment of the permanent employee. If it is purely a temporary,
Were you paid any scale pay?
No scale, fixed salary, but procedure for appointment is the same. They had given a color as if the appointments are permanent, and that is why they are allowed to continue, save and accept payment of salary. Salaries they were not paying. 10 years period, your lordship, cannot be considered a period on temporary basis. Now, your lordship, in between, the department has been assuring these people that your case for regularization has been taken up. And in fact, there is no denial of this fact that their case for regularization was not taken up. What came ultimately in the year 2021, that government has taken a decision to regularize all these employees through RCW schemes, to which I have the grievances. That my selection process is different than the other ad hoc or temporary employees.
So what about the terms of appointment? Leave aside advertisement, the term of appointment, casual peon.
Terms of appointment, casual peon, but this casual peon cannot be by way of a due selection process. Here your lordship will bear one thing, your lordship, that here is a case where due selection process has been followed. That is the main thing here. And not only that, reservation policy has also been followed. And after following the, otherwise in the ad hoc or casual peon, where is the question of following the reservation policy and publication of the select list? Reservation policy, not only that, they have also undertaken the exercise of doing the police verifications. Now, police verification was done. In the affidavit, your lordship, they have stated that this police verification was done so that they could be appointed on regular basis. Your Lordship will turn to page 3 of their affidavit.
Verification was done at stage initial appointment.
Lordship?
Verification done at stage initial appointment.
Initial appointment.
Okay.
At page number 3 of their affidavit, they have stated that it is pertinent to state that the police verification process initiated in the year 2016 also included the staff who were initially appointed on temporary basis so as to be considered for regular appointment. Page number 3, Your Lordship, the first para, the last line. It is also pertinent to state.
We appointed in 2012, 2013, so verification was done 16.
No, earlier also it was done. For 2016 again they had done. With the idea that these people could be given regular appointment. Your Lordship, since I have undergone through this due selection process as per the constitutional scheme, as per the rules, I have acquired a vested right to be considered for the conferment of a permanent status by way of regularization of what? There is no illegality committed so far the selection process is concerned. It's not my case that, it is neither his case that some illegalities were committed during the process of selections. Irregularities is only that instead of giving the permanent appointment, they have given temporary engagement on a sanctioned post. That irregularities is to be regularized by giving a mandamus to the state respondent to confer a permanent.
Yes, you see, the thing is that you slept over your rights, number one. Number two, now the only way your rights can be addressed is slept over rights. You never said that you never paid. If you're putting a sanction post, that means it entails that you're paying you paid a scale. You paid a pay scale, correct? Yes, and then your case will be stronger. That since you're paid on a regular pay scale against sanction post, though they had all the garb of a temporary appointment, but we had come to a regular selection process, and so all the other conditions are being fulfilled, and so there's no impediment for the state respondents to consider to regularize you against the sanction post which is working. Now, what is the fault in your case? From what the court can see, is that now at the time of selection you selected, advertisement is for temporary engagement, appointment is casual peons. Then nothing happened. Then now finally you've come to court saying that now while they were trying to address your rights by saying fine, since you work for so long, we'll give you a regular status, but then in the scheme of things, only the RCW is available.
Yes.
That is what's happened to you.
Yes,
Correct.
that's what
so now you have to argue from that point that how are you entitled in such a manner that that they are stopped from they are stopped firstly from putting in this category that we cannot even regularize. It cannot be under the RCW scheme.
Yes.
Number one.
Yes.
And number two, that but you have to show that in which way I trying to link that your appointment against sanction post at that relevant point of time.
Yes, Lordship.
How do you link that?
That, Your Lordship, there is no denial by them.
Denial by them?
No.
You have to stand on the basis of your own case. There's no question of denial.
Yes. Your Lordship, in paragraph 2.2, I have already stated that these are the sanction posts, and I'll place another.
That's only that goes against you, because usually other cases where a person's upon sanction post, there are some cases he's paid that pay, but they find out one fine day after 10 years, this poor fellow he's been enjoying the pay scale, enjoying the increments, but for some reason he's not been given a regularization.
Lordship, so far, Lordship's first query is concerned.
Yes.
That I have slept over my right is not correct. I have not slept over my rights. The department has taken up my over cases after 4 years of service for regularizations. The process of regularization was continuing and representations was already submitted. It was only in 2021 the government has taken a decision that we will regularize you. And in fact, in the affidavit they have stated we have regularized these people under the RCW.
No, I think the trigger for the case was the second advertisement where they advertised for regular posts against sanction against the vacancies.
Against the vacancy.
I think that is a trigger.
Yes.
That now your claim, your claim, you want to base your claim against those vacant sanction posts, correct?
Yes.
So your relief that you seek, from what I might be wrong, is that since those vacant sanction posts are there,
yes,
and we've come through a regular selection process,
yes,
but we've been treated very unfairly.
Yes,
we've been paid a considerable amount,
Your Lordship.
and so that the government should consider instead of putting you to RCW,
it's not a question
fit
that
us against the
Lordship. It's not a question that we have slept over, right? It is the government which has taken so much time in taking a decision. They have taken the decision only in 2021, by which the personnel department has informed to the SAD, not to even the petitioner. We were informed later that government has taken a decision that you will be regularized under RCW. Then advertisement came. When they have advertised the post, that time, Your Lordship, we have realized that we have been cheated by the government. They kept us in this manner for a period of 10 years. Now, another aspect of the matter, Your Lordship will see that the rules for recruitments are already formulated. Once rules are formulated, the appointment or the recruitment...
You cannot deviate from those set rules. That's
Yes.
what you mean, yes.
No, I'm coming to that. Your Lordship will just give me little time.
I'll give you ample time, don't worry. Don't worry.
I'll...
It's only how to establish the right. We understand, but you have to look for what relief
Yes.
will be entitled to.
Yes, Lordship. Lordship will just come to the rule which I have annexed with my rejoinder.
Yes.
Page 21.
One second. One second, because it's out. Okay. Yes. No, because Dr. Todi is waiting here. That's why I just wanted to check what item was his in the list. What to do, Dr. Todi?
My lord, my friend's case may be continued, my lord. Because I am told that, my lord, he will take time. So, I will, my lord, on some other day. I will do.
Yes, just on consideration, because I saw you waiting. That is why I was asking the court master, Dr. Todi is waiting which item. So, if you are satisfied with that, then we can take up your matter some other day. We'll fix the date. Yes. Right, please continue. Sorry.
Yes, Lordship.
For the interruption.
Page 21 of the rejoinder.
Rejoinder.
Where the rules are annexed. Now,
Yes.
Your Lordship, these rules are formulated under proviso to Article 301. Now, I read the definition of service which is given in clause H. Service means the Meghalaya Civil Secretariat record, supplier, Dapri, Jamadar, etc. and other grade 4 staff service. Then service constitute of what is given in Rule 3. The service shall consist of the following persons, namely, members of the Assam Secretariat Grade 4 and record member of Assam Secretariat, that is previous to formation of creation of the state of Meghalaya. Number B, person requires to any of the posts included in the service prior to 21st January 1972. This is also prior to creation of the state of Meghalaya. Person recruited as grade 4 staff in the Meghalaya Civil Secretariat after 21st January 1972. Persons recruited as grade 4 staff in the Meghalaya Civil Secretariat after 21st January 1972. This is also coming in my favor. Then persons recruited as grade 4 staff in the Meghalaya Civil Secretariat by the Department Selection Committee. Then E is important here, Your Lordship. Persons recruited to the service in accordance with the provisions of these rules. If a person is recruited in accordance with the provision of these rules, he becomes a member of the service. The condition is this: he should be recruited in accordance with the provisions of these rules. There is no dispute so far this factual aspect is concerned that we were not recruited in accordance with the rules. Then Your Lordship will see the composition and strength of the service. Composition. The service shall consist of the following categories of post. Class 3, we are not concerned with...
General, we'll continue at 115 or 110?
115, Your Lordship.
I don't think 115 yet.
115.
Is 115? No.
Yes, my word is 115.
What is passing? We'll continue at 2 o'clock.
Right.
Sin he insists.
Yes.
Yes.
My Lord, may I make a mention of the item 42 and 43, my Lord? Subject to Lordship's convenience, my Lord, can it be taken on Tuesday, my Lord, 23rd?
Sorry, Mr. Dr. Todi.
31st, any date, my Lord?
We'll have to take it after 3 weeks.
After 3 weeks?
There's some, this court won't be available for some other reasons. For that week, it'll be difficult to, I don't want to hold CEV for too long.
Yes, Your Lordship, please, my Lord.
Every time we wait for you, but today you've come and Mr. General put big speed breakers in front of you. So what to do? Every time you ask your junior Mr. Barachaji, every time he's saying my CA is not available. So we adjourn the matter, and this is called Murphy's Law.
Anyway, my Lord, my brief is very small, my Lord. Any date conveyed to your Lordship, my Lord.
Yes.
VIP Lordship.
Yes, Mr. Kumar.
My Lord, I am for the item number 28, my Lord.
Yes.
In this matter, my Lord, we have already filed our...
No, there's other connected matter which they also prayed to be tagged with your matter that you want to file bullet points. So we'll come together with that matter. Up to 20.
My Lord. My Lord. Deeply available Lordship.
My Lord, item
some more matters are there in the list, my Lord, with one with Mr. Bhattacharya.
My Lord, item,
matter, my Lord,
item 51. My Lord, if it is taken up tomorrow, my Lord.
Which one?
Vikas Kumar, my Lord. Vikas Kumar and another. This is that, my Lord, sanitary inspector, my Lord. There is some urgency.
Posts were increased from 4 to 6.
Why you didn't do it last time when court told you to do it?
We did it, my Lord. But, however,
we'll
it is taken up tomorrow.
Tuesday, day after, yes.
Day after, my Lord.
Yes, that Vikas.
Item number 41.
Yes.
Item number 41.
Yes.
This matter over 3 weeks.
41 what matter?
Baby's letter.
On whose behalf you are taking time?
Your Lordship,
Respondent or petitioner? Nothing remains in the case, and we will have it after 4 weeks. Yes.
My Lord, only my humble prayer, my Lord, as far as item 51 is concerned. My Lord, if it is taken up day after, My lord, if it is taken up as a first item in the hearing. It's a very short matter.
You will mention it on that day.
My lord.
Yes. We'll come back at 2. Mr. Jindal left.
I'll be there.
We'll let him complete. He'll take the whole day, I think.
Myself, I will take
Lordship,
Yes,
I'm
Mr.
seeking
Mohan.
indulgence, my lord. For item number 39, my lord. I'm
Yes.
seeking the indulgence of this honorable court if this matter can be taken up tomorrow, my lord.
What's
Because
the
I think my
urgency?
learned senior will take time, my lord. I think.
What's the urgency?
The salary is not been given, my lord, since the pendency of the matter. Actually, we wanted to fall under the purview of the old pension scheme, my lord, since the petitioner was appointed in the year 1991, my lord.
Sure, the fine. Who's the other side?
T.B. Bhattacharya was appearing, my lord.
As I was saying, Mr. Jindal, other matters which people are getting salary, this and that, and matter which is. Anyway, let's see this certainly.
Since the pendency of the matter, since January, my lord.
Call Mr. Bhattacharya. He's supposed to obtain instructions.
Yes, my lord.
Just get him.
Additionally, ji?
KP Bhattacharya.
Oh, KP. Yes. Call KP. Where is he?
Lordship, with regard to this matter, Mr. Bhattacharya has requested that if this matter can be taken up on another occasion, my lord.
No, you see, the thing is that last order,
My lord, yes,
he was
regarding the salary, my lord.
he was supposed to get instructions,
My lord,
and on the
he
miss
also
case filed by
informed-
Mr. Momin,
My lord.
and so he said was put inside. He didn't get instructions.
My
He
lord,
paid for 2 more time. Let it come tomorrow.
Mr. KP has also informed me with that regard. Also, he has already received instruction through phone, my lord.
What are the instructions?
However, I think neither he has received in writing. So he's waiting for the department to
Then
give
you ask the officer, who's the officer concerned, to appear tomorrow.
My lord, may I have this matter day after tomorrow?
Day after tomorrow, otherwise officer has to appear.
My lord.
Yes. By order dated 25/4/2023, Mr. K.B. Bhattacharya had sought 2 weeks further time to obtain instructions on the listener's application filed by the petitioner. Stop. Like for today, MSR Kolni submits that the instructions have been received, but however the same were telephonic.
Writing, my lord. No
No
official.
official instructions. Stop. This is matter day after. If instructions not come to concerned officer, who's the officer here?
I do not know which officer. And the department also on that. He just informed me this matter pertains to the education department.
In
That's
fact,
why
my lord, the treasury officer is actually insisting the petitioner to
No instructions ever.
offer the new pension scheme, my lord. But we have not made him a party.
Is this matter only right for instruction?
So instruction, the concerned officer will have to personally appear to his court on the next day. Get assigned by the after,
I'll inform
otherwise,
Mr. Kitchen.
otherwise yes.
Please, Your Lordship, I beg to mention item 52, Your Lordship, if this matter can kindly come out after 3 weeks.
Mr. Jha objecting. 52. Rakesh.
No, your own Prakash.
4 weeks. Yes. Yes. Feet by your theory, steps by your theory. Mr. Vinzil, have any authorities?
Yes, Lordship. I'll cite everything, Your Lordship. Just allow me to proceed 10 minutes. Your Lordship, I was on the rules, page 22 of my rejoinder. Page 22 of the rejoinder, clause E. Persons recruited to the service in accordance with the provisions of these rules.
Yes.
What I want to submit with reference to this clause, that so far rules are concerned, rules makes no distinction between regular appointment, ad hoc appointment or casual appointment. Rules only say that if the appointment is in accordance with the rules, you become member of the service. Whether that appointment is temporary appointment or it is a regular appointment, so far the rules are concerned, it makes no difference. Then, Your Honor, Rule 4, there are three categories. There are two categories. First category includes the class 3 and second category includes class 4, wherein Your Lordship will find the post of PN falls under clause 4 categories. Sub-rule 2 says each of the 13 category of post, that is in class 3 and class 4, each of the 13 categories of post in sub-rule 1 shall form an independent cadre.
Where reading?
Sub-rule 2, page 23. Page 23.
Okay.
Each of the 13 categories of post in sub-rule 1 shall form an independent cadre. Member of one cadre shall have no claim for appointment to any other cadre except in accordance with the provision of these rules. Then I also read Rule 5, strength of service. The number of posts, permanent as well as temporary, under each of the category mentioned in sub-rule 1 of Rule 4 shall be such as may be determined from time to time. Your Lordship, then I come to Rule 10. Rule 10 speaks about the process of appointment, recruitment. Lift operator, sweeper, cleaner, chowkidar, PN, key, chowkidar, watchman and malis appointed to the post of lift operator, sweeper, cleaner or key, chowkidar, watchman and malis shall be made by direct recruitment from the list prepared by the selection committee under Rule 18. So the only mode of appointment, recruitment of the PN is the
Rule 10.
Direct recruitment. And by a selection committee, then Your Lordship, I take to Your Lordship Rule 16. What is the procedure for appointment of appointment by direct recruitment? Condition of eligibility. In order to be eligible to appear at the interview, candidate must satisfy the following condition, namely nationality, age 18 years and 70 years, provided that the upper age limit in any individual case may be relaxed by the appointing authority in accordance with any general or special order issued by the government from time to time, provided further that the upper age limit may be relaxed in respect of the candidate so and so. Education qualification is class 6, from class 3 it was amended to class 6, or a lower primary examination or equivalent examination. Marital status must not have more than one spouse, provided that the government may, if it is satisfied, there are special grounds for doing so, exempt any person from the operation of the clause. Your Lordship, with regard to Rule 16, my submission is this, Your Lordship. The candidates who are, the petitioner who are appointed, they all fulfill the requisite eligibility criteria.
Okay.
Then Your Lordship, Rule 18 speaks about as soon as occasion arises, the appointing authority shall take up with the intimate committee the approximate number of posts. This is how the procedure goes. Then Rule 19, subject to the provision of Rule 2021, candidates shall be considered for appointment in the order in which their name appear in the list, subject to reservation for members of the scheduled caste and scheduled tribes. In the instant case, Your Lordship, reservation policy is also followed here. Then, Your Lordship, Rule 20, No candidate shall be eligible for appointment who after such medical that Rule 20 speaks about medical examination. Then most important is Rule 20.
They all medically examined also?
Yes, Lordship.
All fit?
Yes. We submit the medical certificate. Confirmation. Subject to availability of permanent posts. Your Lordship will, once again I read. Subject to availability of permanent posts, every member of the service shall be confirmed in the post to which he is appointed if he has completed at least 5 years of service to the satisfaction of the appointing authority and is otherwise considered fit for confirmation. Your Lordship,
yes.
After 5 years of service, I gets a vested right of confirmation subject to availability of the vacancies. Vacancies were always available and are still available, but we are not confirmed under Rule 22, and after completion of 5 years of service, be it as because the rule doesn't make any distinction between temporary appointment or permanent appointment or regular appointment. What it says that if you are appointed in accordance with the rules, you become member of the service, and if you become member of the service,
subject to confirmation.
Yes.
Subject to availability of post.
So under Rule 22.
So now your case is that, look, once you've put your head in into the secretarial administrative service, in any mode of recruitment, once you enter, you become member.
Not any mode, Your Lordship.
By the method.
By the method prescribed.
Then once you are appointed, that means you are considered a member of the service.
Yes.
And once a member of the service, you are bound by the rules.
You are bound by the rules.
And then your confirmation should come, all these other things.
Yes, Lordship. My submissions are twofold. First, I get the vested right under the rules, and even if there is no rule, I still get the right of regularization by conferment of the permanent status. I'll cite authority on both the sides that when rules are formulated, the state
sine qua non.
Yes, the state is bound to follow. Your Lordship, I read so far the sub-rule 3 of Rule 22. It takes care of the temporary or officiating.
1 second, Mr. Jindal.
Subject to the aforesaid condition. Lordship, I am reading sub-rule 3. A temporary or officiating member shall be liable to be discharged. Sub-rule 3 of Rule 22.
Okay.
A temporary or officiating member shall be liable to be discharged or reversed to the next lower grade of the service if he fails to render satisfactory service to the government. He is found on subsequent verification that he was initially not qualified for the appointment, or that he has furnished any false or incorrect information with regard to his or her appointment. Your Lordship, a person who is appointed on temporary basis, that also takes care. If he is not discharged in accordance with these conditions, then he has to be confirmed.
Yes.
Then your Lordship will see how the seniority of these persons are determined. Rule 23, relevant is sub-rule 3 and 4. The inter se seniority of persons mentioned in clause C of sub-rule 1 of Rule 3 shall be according to the date of appointment, such person shall be junior to all falling under sub-rule 2. Sub-rule 4. The inter se seniority of person appointed under clause...
Just come again. The inter se seniority of
person mentioned in clause C. That clause C is...
D1.
Clause C...
No, clause D. You're reading the...
Yes, clause 3 I am reading.
Reading clause 3, yes.
The inter se seniority of person mentioned in clause C of sub-rule 1 of rule 3. Rule 3, Your Honor, C speaks about, if Your Lordship turns to rule 3.
Yes, yes.
Persons recruited as grade 4 staff in the Meghalaya Civil Secretariats after 21st January 1972. Then class sub-rule 4 deals with D. Persons recruited as grade 4 staff in the Meghalaya Civil by the Department Selection Committee. So for C, sub-rule 3 comes into picture. The inter se seniority of person mentioned in clause C of sub-rule 1 of rule 3 shall be according to the date of appointment. According to the date of appointment, such person shall be junior to all falling under sub-rule 2. Though my name will, our names will come down to the persons who are appointed under sub-rule 2. And inter se seniority of the person appointed under clause D of sub-rule 1 shall be in order in which their names are arranged by the government for purpose of appointment. Such person shall be junior to all persons filing under sub-rule 2. So the select list, Your Honor, gives this order of seniority. And seniority will be determined in accordance with that, Your Lordship. Now, what I wanted to point out to Your Lordship, that state has formulated the rules.
Yes.
And the state is bound by these rules. And these rules makes no distinction between the appointment, be it be a casual appointment, be it be a temporary appointment. What it requires, that recruitment in accordance with the rules. If you are recruited in accordance with the rules, you become member of the service. And if after 5 years, within 5 years, if I am ad hoc appointment, let my appointment go within 5 years. But the moment I cross 5 years, I acquire, say, vested right to be confirmed to the post.
Because confirmation, but is subject to regular appointment. Anyway, let's continue.
Confirmation is
a different thing. Anyway, I will not go there. You just please continue.
Yes, Lordship. Now, the question, Your Lordship, so far the availability of the vacancies are concerned, even as on date, there are 77 posts which are advertised. And the affidavit of the Under Secretary to the Government of Meghalaya also states that these 77 does not include the name of those persons who are appointed on casual basis following the selection process. So, meaning thereby that there are ample vacancies. Now, I just received one RTI information which was not to one of the petitioner, but somebody else has applied, and the position under 2019 is very much given there. If I am permitted, I will just place in order to show. Yes. In inviting a reference to the subject cited above, I am directed to furnish the required information as follows. Vacant post in Secretariat Administrative Department, Nazarat, SADN, Grade 4, 194. Your Lordship, as on 2019, November 2019, the total vacant post of class 4 were 194. Total number of employees who are permanent employees in SADN grade 4, 584. Total number of employees who are permanent employees in so-and-so, 580s. Total number of employees who are casual employees in SAD grade 4, 2,215. Total number of employees who are casual employees in SAD and grade 4 who have passed their written examination conducted by the authority concerned in previous year, that is 131.
You fall in this one?
I fall under this category. There are 131 persons out of that select list which have been appointed. Total number of employees who are casual employees in SADN grade 4 who have not passed any written examination conducted by the authorities concerned in previous year, 84. So these are 84 are the persons who have entered in the service back door, not by do. So there is a difference between number 4 category and number 5 category. Both cannot be placed on the same footing. RCW, what they are telling that we are regularizing you through RCW. RCW is with respect to category 5. Category 5. Pay scale for casual employee in SADN who has passed their qualification examination, fixed remuneration 13,600 per month. Those who passed qualification examination, their salary is 13,600. Pay scale of casual employee in grade 4 who has not passed any of their qualification examination, daily wages. Pay scale for employees in SADN who are permanent employees, 17,400. Permanent employees basic pay is 17,400 and total it comes to around 36,000. This is 17,400 is the basic pay. Any deduction made, no transfer is made. Then your Lordship will come to the column number 10. Has there been any steps taken by the state government or the department concerned to regularize the casual employees? If yes, details and photocopies of such documents to be given, if any. The regularization of casual employee is generally not permissible under the rule. The relevant answer to the question is at 11. Whether the casual employees working under grade 4 SADN is sanction post or not. All posts, regular or casual, are not without sanction. So, your Lordship, the posts are sanctioned. This is what the RTI information reveals. And that is the position in 2019. After that, it has not undergone change save and except the number of the casual employees without written examination have gone double. So,
yes,
your Lordship, this proves the point that the posts in questions are sanction posts. Sanction posts.
See, sanction posts and government sanction, two meanings. Now you cannot make a temporary appointment without the approval from the government also. So that is the sanction given. A sanction post is a post is created. It is casual post can be sanction post. A sanction post is a post that's created. Now we go for creation of post, then we ask the government please sanction some like for the High Court. So we require another court master. We require some more PS. Then sanction posts are created.
I fully understand
Yes.
what your lordship is trying to convey to me. I have understood this thing. Lordship, the point here is this. Is it not a bounded duty of the state to reflect all these things in the affidavit?
Why?
They are filing a cryptic affidavit.
They'll go against them.
That's what I am telling. That's what I am telling. No, what they have stated. Paragraph 7 I have already pointed out in their affidavit. Let's see first paragraph 6. Paragraph 6 of the affidavit of the Undersecretary filed on behalf of the respondents. That with regard to the averments made in paragraph number 2.2 of the writ petition, your lordship just may have a look on 2.2 of my petition. There were initially 60 vacant sanction posts of PN in Secretariat Administrative Department under the Government of Meghalaya, Shillong during the year so-and-so. And the department had obtained the approval of personnel so-and-so, by their endorsement number so-and-so and finance concurrence on so-and-so for appointment of the PN through written test and personal interview. The said posts were advertisement by the department-wide advertisement number so-and-so. The department, for the reason best known to them, did not advertise the post on regular basis, but the said post were to be filled up on temporary daily wage basis at the rate fixed by the government. The minimum age prescribed was not less than these other things are there. What reply comes is paragraph 6 of the affidavit. That with regard to the averments made in paragraph number 2.2 of the writ petition, the answering respondents state that with the appointment of various officials in different departments, the requirement of grade force staff to be attached to these offices of various functionaries also equally arose. The requirement of these grade force staff was initially about 91. However, since there was a restriction in creation of regular posts, as such, in order to ensure smooth functioning of the offices, the department proposed the requirement to be met through casual or contractual appointment purely on daily wage basis, and in pursuance to which an advertisement dated so-and-so was issued, by virtue of which the petitioner were appointed purely on temporary, casual and daily wage basis at the rate fixed by the Labour Department. Your lordship will find in paragraph 6 of the affidavit of the state that they have not at all denied that the post in question were not vacant and sanctioned post. And on the contrary, they contradict this thing in paragraph 11. Paragraph 11, second part, page number 4. The answering respondent states that it is also a fact that with regard to resolve the pending regularization of service of the employees, the answering department decided to issue advertisement only for the vacant post without accounting.
Where reading?
Page 4. Page 4 of the affidavit.
Yes.
The answering respondent states that it is also a fact that with regard to resolve the pending regularization of service of the employees, the answering department decided to issue advertisement only for the vacant post without accounting the posts which has been already occupied. So your lordship will find without accounting the posts. meaning thereby I am already holding the posts.
Anyway, yes.
And
Mr. General, are those people behind your clients?
yes, Lord.
Have you taken leave to come attend court? You stand up when you talk to the court. You please stand up when you talk to the court. You're not taken leave. When you're attending the court, you come from the office. Very good. Yes. Yes. Please continue.
Should I ask them to go?
No. That's sure the conduct. Anyway, yes, please continue. Yes, now we said that the decision is re-informed.
Just 1 minute, sir.
Yes.
Now, in paragraph 13, hence the paragraph 13 that with regard to amendment made in paragraph so and so, in the foregoing paragraph, in pursuance to the initiative for regularization of the employees, the government has assured regularization under the regular casual worker scheme. So your lordship one thing will find that there seems to be no dispute on the point that they are to be regularized.
Yes.
And only the dispute is coming that government is trying to regularize them under RCW. And what we are asking that
we absorb the sanction post.
We should be absorbed on the sanction post.
Yes.
We have reached to that stage. Then your lordship, I also read page 5, second para. The answering respondent further states that the petitioners are well aware of the fact that the post advertisement in 2012 was a purely temporary post. This is not correct, that they did not advertise for the temporary post. Whether posts are temporary or permanent, that was not mentioned in the advertisement.
Okay.
Irrespective of the scheme, please, irrespective of the same, the department is committed to observe the petitioner by way of regularization under the regular casual worker scheme. Hence, it is to be noted that the proposal for regularization under the regular casual worker scheme pertains only to the employees appointed to the category of casual or contractual PN to which the petitioner herein belongs. Here, so far this point is concerned, this statement is concerned, your lordship. My submission is this, that the government is putting two unequal as equal. Yes. There are casual and temporary employees who have come without due process of selections, and there are casual and temporary employees who have
come through
the selection process.
Yes.
There is a wide difference between these two. Government is telling that we are regularizing the casual. But we stand on different footing.
Yes.
If there is
that is your interpretation of this.
Yes.
Of this
yes.
statement in the affidavit. Okay.
Yes, lordship. Your lordship, I also once again read page 7. Your lordship will come.
Yes.
However, page 7, 1, 2, 3, 4, 5th line. However, irrespective of the same, presently, under the regular casual worker scheme, the services of the petitioner has been considered and approved by the competent authority on fulfillment of the requisite qualification. Even they have approved.
Yes.
That you are to be put under the RCW. My grievance is this, Your Lordship, that this RCW scheme is not at all applicable.
You have made that point, yes.
Is not at all
You
applicable.
already made that point, yes.
And even in the scheme itself, which I have pointed out on the last occasion, just to point out only one paragraph of the scheme.
Yes.
Page 93. Your Lordship, this scheme came into the picture, came into force on 16 September 1996. And paragraph 3 of the scheme says, a casual worker who has immediately before the date of coming into force of this scheme been working at such for a continuous period of not less than 10 years may be conferred with a status of a regular casual worker from such date, not being a date earlier than the date this scheme came into force, as the appointed authority may by order specify. The very phraseology used in the paragraph 3, Your Lordship, will suggest that the status of RCW will be conferred only to those employees who have served for 10 years prior to the commencement of this scheme. So, this scheme under which we are trying to we have been approved to be regularized has no application. This is another illegality which has been committed by the state, and they are perpetuating the illegality. Before I go to Your Lordship,
yes, come to the authorities.
The authorities,
yes.
Only on the second point, that my case is also this, that irrespective of the conferment of the status of permanent employee, I am otherwise entitled for equal pay for the work which I am doing equally as the regular permanent employees, Your Lordship. The statement is made in paragraph 3.5 of my writ petition at page 18.
Okay.
Initially, Lordship got it?
Yes, yes.
Initially, the department-wide office order 12th March 2013 made appointment for the 60 post of PN against the regular sanction vacant post on a fixed remuneration of rupees 4,000 per month, which by itself is improper, as when the posts are sanctioned posts, it carries with it the regular scale of pay. The state cannot exploit its citizen and appoint the petitioner on a fixed salary on casual basis. The state respondents are acting against the mandate of the Constitution by exploiting its citizen in the matter of public employment. So, what reply comes from the state, that is at para 14 of their affidavit, Lordship.
Yes, you can read.
Yes. That the averment made in paragraph number 3.5 of the writ petition is denied as incorrect. There is just a
ball denial.
Ball denial, Ball denial. Then your Lordship will see my rejoinder to this paragraph Lordship will just give me. Your Lordship will come to paragraph 12 of my rejoinder, that the writ paragraph 12 of my rejoinder, page 16.
Yes.
That the writ petitioners in para 3.5 of the writ petition have also claimed the equal pay for equal work and alleged exploitation and forced labor on the part of the state respondents in appointing the writ petitioner by way of due process of selection on a fixed remuneration of rupees 4,000 per month. The state respondent, in reply to the averment made in para 3.5, has not seriously contested the claim of the writ petitioner in para 14 of the affidavit, save and except to say that the statement made in para 3.5 of the writ petition is denied. It is once again reiterated that though the principle equal pay for equal work is not a fundamental right, but in view of the provisions contained under Article 39D, read with Article 14 and 16, and also the socialistic philosophy adopted by the Constitution by adding the word socialist in preamble, the said principle of equal pay for equal work has acquired the status of a fundamental right. A three-judge bench of the Apex Court in the case of Randhir Singh versus Union of India has held that construing Article 14 and 16 in the light of preamble and Article 39D of the Constitution of India, the principle of equal pay for equal work is deducible from these articles. The judgment in the case of Randhir Singh was followed by another three-judge bench in Dhaiwat case, which was affirmed by the Constitution bench in D.S. Nakara and other versus Union of India. In the above context, the writ petitioner further states that as per advertisement dated 20th-1-2012, the petitioner was required to possess the same qualification and age as is prescribed for regular permanent employee as per Rule 1986 at the time of recruitment. The mode of selection is also the same. There is also no difference as to the liability of member of the service as regards their transferred duties and responsibilities. The deponent further states the duties and its volume, responsibility and reliability of the petitioner employed as casual worker on a fixed remuneration is the same as that of peon employed on permanent basis on a regular pay scale. There is no qualitative difference as regard reliability and responsibility of the casual peon and that of permanent peon. Para 27.3.2 of Chapter 2 of Meghalaya Secretariat Manual, read with appendix of the said manual, specify the duties and responsibility of the peon, which are same to the casual appointed on a fixed wages and permanent. The performance of the writ petitioner is evaluated and monitored by asking them to submit their ACR, which has been submitted to the department from time to time.
So the ACR is maintained also.
The ACR also is maintained.
Yes.
And your Lordship will turn to page 35 of my rejoinder. The manual of the SAD prescribes the duties of PN, page 35. All these duties which are enumerated here are similar, which are performed by the PN appointed on whatever basis the state may call it, casual worker, contractual worker, or ad hoc workers. These are the same. When duties, responsibilities, and liabilities are the same, it is the constitutional mandate that there should not be any discriminations with regard to the payment.
Yes.
And
the city authorities, the
yes,
general.
yes.
I think you made a point. Yes.
This is without prejudice to the whether regularization or no regularization. Yes, Lordship will first authorities I will cite on the question of regularization and this confirmation of the permanent status, that 1972 1 SCC 409. 1972. Yes, Lordship. This is followed in the Uma Devi case. That's why I am referring.
72.
1972, Volume 1, SCC 409.
Yes.
Paragraph 2, 23, 26, and 28. I read what were the rules which were impeached in these writ petitions. The rule impeached by the appellant are as follow. In exercise of the power conferred by the proviso to Article 309 of the Constitution of India and all other powers enabling him in this behalf, the Governor of Mysore hereby makes the following rules. Title: these rules may be called so and so. Number 2, provisions relating to regularization of appointment of Principal School of Mines, Oregon Scholar Goldfield. Notwithstanding any rule under the proviso to Article 309 of the Constitution of India or any other rules or order in force at any time, Dr. T. Timaya, BSc Honours, PhD London, so and so, shall be deemed to have been regularly appointed as Principal School of Mines, Oregon Scholar Goldfield with effect from February 15, 1958. So these rules are formulated under 309 of the Constitutions, and these rules were assailed because these rules have stated that notwithstanding any rules, the appointment of so and so is taken to be a regular appointed principal with effect from so and so date, so and so date. So this rule was assailed. Now I come to paragraph 8, your Lordship will find in the month of May 1964, rules of recruitments were framed by the government for the Department of Technical Education. Already there were in existence 1965-64 rules. Then in the year 1967, rules were made under Article 309 of the Constitution, regularizing the appointment of respondent as principal. Then your Lordship, come to paragraph 23.
Yes.
It was contended on behalf of the state that under Article 309 of the Constitution, the state has power to make a rule regularizing the appointment. I read once again, Your Lordship. It was contended on behalf of the state that under Article 309 of the Constitution, the state has power to make a rule regularizing the appointment. Shelter was taken behind Article 162 of the Constitution and the power of the government to appoint. No one can deny the power of the government to appoint. If it were a case of direct appointment, or if it were a case of appointment of a candidate by competitive examination.
Is it a contention or is it a finding of the court?
Lordship.
Is it a contention of the state?
Contention, Your Lordship.
Is a contention, then
I am
no.
coming to the finding, Your Lordship. I'll come to the finding.
Come to the finding, what is the purport of 309 and 162?
Yes, Lordship.
Other thing.
Then paragraph 26.
Yes.
Paragraph 26. The contention on behalf of the state that a rule under Article 309 for regularization of the appointment of a person would be a form of recruitment read with reference to power under Article 162 is unsound and unacceptable. The executive has the power to appoint. That power may have its source in Article 162. In the present case, the rule which regularized the appointment of the respondent with effect from February so-and-so, notwithstanding any rule, cannot be said to be in exercise of power under Article 162. First, Article 162 does not speak of rules, whereas Article 309 speaks of rule. Therefore, the present case touches the power of the state to make rule under Article 309 of the nature impeached here. Secondly, when the government acted under Article 309, the government cannot be said to have acted also under 162 in the same breath. The two articles operate in different area. Then comes, Your Honor, Lordship, the actual finding. Regularization cannot be said to be a form of appointment. Counsel on behalf of the respondent contended that regularization would mean conferring the quality of permanence on the appointment, whereas the counsel on behalf of the state respondent contended the regularization did not mean permanence, but that it was a case of regularizing of the rules under Article 309. Both the contentions are fallacious.
Well, what you're trying to show with the judgment is that regularization cannot be a form of appointment, correct?
RCW
and if Article 309 and after the rules remain under 309, the recruitment has to be done under 309 only.
Yes, Lord.
That is the point.
Yes, and regularization through the RCW is not contemplated. It doesn't come even within the power of the
an appointment. Yes.
Power of the state under Article 162. Just allow me to read last 2-3 lines. If the appointment itself is in infraction of the rule, or if it is in violation of the provision of the Constitution, illegality cannot be regularized. So, my appointment, Your Lordship, is not in infraction of the rules. And if it is infraction of the rules, then no amount of regularization can confer a status of permanence.
Can cure that, I mean, yes.
Then, Your Lordship, just have a look on paragraph 28, if something is...
28.
Then that also on the merit, main thing is paragraph 26. Then, Your Honor, next case is, which is also referred in Uma Devi. Before I come to Uma Devi, I'll just refer 1 or 2 para of 1979.
Yes.
4 SCC.
4 SCC.
507. Nagarajan case.
Nagarajan.
3-judge bench. Paragraph 23 to 25. It deals with what is the difference between regularization and permanence. The paragraph 23 I am reading, Lordship.
Yes.
Order made by the state government later on And right up to the October 31, 1961, when the direct recruits was appointed assistant engineer, did not improve the position of any of the promoted men. Those orders were either silent on the point of the nature of the tenure of the promotees as assistant engineers, or stated in no uncertain terms that the promotees would hold the post of assistant engineer on a temporary or officiating basis. That is why Dr. Chitle and Mr. Sen so and so. The combined effect of which was to promote the said 107 officer as assistant engineer with effect from so and so on a regular basis. It was argued that regularization of the promotion, given it the color of permanence and the appointment of the promotees as assistant engineer, must therefore be deemed to have been made substantially right from November 1, 1956. The argument, however, is unacceptable to us for two reasons. Firstly, the word regular or regularization do not connote permanence. They are terms calculated to condone any procedural irregularities and are meant to cure only such defects as are attributable to the methodology followed in making the appointment. So here, Your Lordship, what is this what is that irregularity? That is, instead of giving the permanent basis, they have given it on ad hoc basis, but followed the entire selection process. So it is in that context, Your Lordship, then in paragraph 24, they have referred the earlier case which I have pointed out. Then, Your Lordship, I come to the Uma Devi case, the constitutional bench case, paragraph 6. 2006 4 SCC.
Yes.
Page number 1.
Yes.
Constitution 7 judges bench case. I read the paragraph 6. The power of a state.
Yes, yes. Continue. Yes.
The power of a state as an employer is more limited than that of a private employer, inasmuch as it is subject to the constitutional limitation and cannot be exercised arbitrarily. Article 309 of the Constitution gives the government the power to frame the rules for the purpose of laying down the condition of service and recruitment of persons to be appointed to the public services and post in connection with the affair of the union or any of the state. That article contemplates the drawing up of a procedure and rules to regulate the recruitment and regulate the service condition of appointees appointed to the public post. It is well acknowledged that because of this, the entire process of recruitment for services is controlled by detailed procedure which specify the necessary qualification, the mode of appointment, etc. If rules have been made, this is important, Your Lordship.
Yes.
If rules have been made under Article 309 of the Constitution, then the government can make appointment only in accordance with the rule. The state is meant to be a model employer. The employment exchange compulsory notice, this is not only the thing which if rules have been made
Yes,
under
you made your
Article,
point, yes.
Yes. Then, Your Lordship,
You mean they cannot deviate from any, they cannot resort to any other method of recruitment.
Yes,
if the rules prescribe that this is the way it should be done.
let's, Lordship. Then, Your Lordship, paragraph 15 and 16, where they have discussed the earlier two cases which I have pointed out.
Yes.
Paragraph 15 of the same judgment. Even at the threshold, it is necessary to keep in mind the distinction between regularization and conferment of permanence in service jurisprudence. In state of Mysore versus S.V. Narayanappa, This court stated that it was a misconception to consider that regularization meant permanence. In R.N. Najupampa T. Timaya, this court dealt with an argument that regularization would mean conferring the quality of permanence on the appointment. This court stated, paragraph 26 is quoted, which I have already read in the previous judgment.
Yes.
Then paragraph in B.N. Nagarajan versus State of...
This also here.
I refers. Then what they have to say in the last 5 lines?
Yes.
These decisions and the principle recognized therein have not been dissented to by this court, and on principle we see no reason not to accept the proposition as enunciated in the above decisions. We have therefore to keep this distinction in mind and proceed on the basis that only something that is irregular for want of compliance, that one of the elements in the process of selection which does not go to the root of the process can be regularized, and that it alone can be regularized, and granting permanence of the employment is a totally different concept and cannot be equated with regularization. Then, Your Lordship, I read paragraph 43.
Yes.
Thus it is clear that adherence to the rule of equality in public employment is a basic feature of our Constitution. And since the rule of law is the core of our Constitution, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with the requirement of Article 14 read with Article 16 of the Constitution. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. This is, Your Lordship, most important. This is where I get the right by the decision of the 7 judges of this Honorable Apex Court, that there is no dispute that my appointment is.
Well, that's it. I mean, you have vested with the rights. You keep on saying that, yes, that you come by regular section process.
Yes, Lordship.
And being deprived at the end, yes.
Then, and
concept equality,
even if we keep the rule aside for the time being,
yes,
then also, otherwise also I get a right for confirmation of the permanent status. That is what is provided in an exception carved out by the Constitution bench in paragraph 53.
Yes.
53 of the judgment. One aspect needs to be clarified. There may be cases where irregular appointment, not illegal. Irregular appointment, not illegal appointment, as explained in S.V. Narayanappa, R.N. Najumpa and B.N. Nagarajan, and referred to in para 15 above, of duly qualified person in duly sanctioned vacant post might have been made, and employees have continued to work for 10 years or more, but without the intervention of order of the court or tribunal. The question of regularization of the service of such employees may have to be considered on merits in the light of principles settled by this court in the case above referred to and in the light of this judgment.
So 53 is fine. It is a one-time measure, and then there were other Christian judgments was after that.
Yes,
we're seeing that the exceptions have been carved. It was not done within that period. There has been some overlooking. Then that Bangalore case is there.
Only the thing,
yes,
Lordship, that
No, well aware.
It is a case in itself, because here the petitioners are before your lordship who have been selected by the due process.
Yes. No, that is the court has noted that. They have come through a selection process, but
then
only the
your lordship-
assessment is against an appointed casual. Yeah. Yes. Yes, Mr. General.
Yes, lordship. Then I'm some judgments, your lordship, on one judgment, your lordship, 1987, volume 1.
Equal pay, equal work.
No, that is that state should exercise the power within the constitutional limit. That is 1987, 1 SCC 378, 5 judges. Paragraph 3. Exercise of the power of the state should be within the constitution limit.
It is famous Wadhwa case.
Wadhwa case. Then, Your Honor, for equal pay for equal work.
You cited the two judgments in the
Yes, three judgments are there, and which have settled the law once for all.
That is
First
cited the
one
judgments
is,
in para 3.5.
Yes. First one is Randhir Singh, 1982, volume 1, SCC 618, 3 judges.
Just come again,
1982,
yes,
volume 1, SCC 618, 3
Para.
judges, paragraph 8.
Yes.
May I read it?
Yes.
Paragraph 8.
Same one that you read in your paragraph.
No,
the
it was-
constitutional
no.
goal under Article 39. The same you have reproduced in your in the
Yes, I
rejoinder.
took phraseology from here.
Yes.
Because
I mean, you've
I done little homework while.
you've drawn the imported the findings
Yes,
into that.
Let me just see whether I have missed something.
No, it's all right because it goes to
No, I missed.
all the labor codes of the world. Yes. Yes.
I'll just see it, how it goes.
Just with regard to the Delhi drivers, right?
Yes.
Yes.
Uh,
Serving different departments.
Yes, it's different
Yes.
department. Now, here, what is the law point which is decided? That though equal pay for equal work is not a fundamental right, but in view of the provisions contained under Article 38(2), 39(d), Article 14, 16, and preamble of the Constitution, by adding the word socialist, it has acquired the status of a fundamental right.
Of course, that is the settled law now. If you do it,
Yes.
unless there's no differential criteria between the duties performed
Yes,
or the hours
yes,
that they work, then
yes.
that means they will be entitled to equal pay, equal
Equal
work.
pay, irrespective of the fact that whether they are holding the permanent post or they are holding
But whether that's followed in all cases, that's a different thing. But stipulation, of course,
are there, and
yes.
and another three judge bench judgment is 1990, volume 2, 1990,
Yes.
volume 2, SCC 396, paragraph 4, 5, 8, and 11.
Okay.
These three judge bench judgment followed Randhir Singh.
Yes, same paragraph we quoted.
Yes.
Para 8.
Yes.
Then,
Then, Your Lordship, The last judgment is which has approved this Randhir Singh is the Constitution Bench judgment reported in 1983, 1 SCC 305, paragraph 32 and 33.
Para 32, 33.
Yes, Lordship. Paragraph 32 and 33.
This is Nakara.
DS Nakara. You say, I think 5 judge or 5 judge, I think.
This is regarding entitlement to pension. Where,
Yes,
where
it was
where does
relating to
apply?
the equal pension.
Yeah, where does apply to your?
Yes, Lordship, paragraph
Para?
32. 32.
Yes.
Having focused our attention on the conspectus of element and incident of pension and main question may now be tackled. But the approach of the court while considering such measure is of paramount importance. Since the advent of the Constitution, the state action must be directed towards attaining these goals set out in Part 4 of the Constitution, which when achieved would permit us to claim that we have set up a welfare state. Article 38(1) enjoins the state to strive to promote welfare of the people by securing and protecting as effective as it may be social order in which justice, social, economic and political shall inform all institutions of the national life. In particular, the state shall strive to minimize the inequality in income, endeavors to eliminate inequality in status, facilities and opportunities. Article 39(d) enjoins a duty to see that there is a equal pay for equal work for both men and women, and this directive should be understood and interpreted in the light of the judgment of this court in Randhir Singh versus Union of India. Your Lordship, there is also an plea taken by the state that we have given, they have accepted. We have given them the fixed salary and they have accepted, and there is
That's an interesting point. Yes.
no such.
Yes.
Now, one aspect your Lordship will also examine.
Yes.
In my, it is also my case that this regular pay was denied, or the permanent status was denied for the purpose of declining the petitioner to get the regular pay scale for all years to come. There was no other intention other than to see that these people
deprive them of the legitimate service benefits.
Yes. And in that connection, your Lordship, I just take 3 judge bench judgment of 1996, volume 2, SCC 293.
1 second, just come again.
1996.
Yes.
Volume 2, SCC 293, 3 judge, relevant para 18, 22 and 28. Justice, Chief Justice Amby's judgment. Paragraph 18. This takes us to the second main question as to whether on the facts of the present case it could be held that the appellants were guilty of adopting unfair labor practice. This is also one of my allegations. As already pointed out, the respondent alleged the aforesaid act by relying on what has been stated under item 6 of Schedule 4 of the State Acts, which reads as follows. In the State Acts, the phraseology which is used here is the same as that of the Industrial Dispute Act, which I have on the last occasion, if your lordship, status of permanent employees, in as much as giving of this status would have required the employer to pay the workmen at a higher than the one fixed under the Minimum Wages Act. We can think of no other possible object, as it may be remembered that the Panchagam provides scheme. This is, your lordship, this is what is important. We cannot think of any other possible object, your lordship. Then, your lordship, paragraph 28.
Financial implications.
State has taken the plea of financial strain.
Yes.
Insofar as the financial strain on the state exchequer is concerned, which submission is sought to be buttressed by Shri Dhalokia by stating that in the forest department itself the casual employees are about 1.4 lakhs, and if all of them were to be regularized and paid at a rate applicable to the permanent workmen, the financial involvement would be in the neighborhood of rupees 300 crore, a very high figure indeed. We have not felt inclined to bear in mind this contention of Sri Dhalokia, as the same has been brought out almost from the hat. The argument relating to financial burden is one of despair or in terrorum. We have neither been impressed by the first nor frightened by the second, in as much as we do not intend that the view to be taken by us in this appeal should apply properly to all casual laborers of the forest department. It will, your lordship, my case is also this, that this will apply only to those people who have been before your lordship and they have been selected or recruited in accordance with the due process of law. Because I am not holding the brief for other people. I am holding the.
How many of you were recruited, apart from
petitioners? Petitioners, 37 are in one petition.
In 462 is 16 of them. 16 petitioners in 462 and 38 in 483.
Yes. So
how many of you were recruited at a point of time altogether?
Your lordship, as per RTI information, it comes to 131.
131. Okay.
131. But out of 131, 54 are before your lordship.
Yes. Right.
And apart from the selection process appointee, there are other people who have come, dehorsed the rules, and they are.
No, that we're not concerned with them.
We are not concerned about that. We are not concerned about this.
So 54 have come, 87 have been left out, who were similarly recruited.
Yes, lordship.
Okay.
Lordship.
Right.
No. So, lordship, in conclusion, your lordship, I will say that these are, after all, class 4 employees, and they fulfill all the requisite qualifications prescribed under the rules. They have undergone to the selection process. Reservation policy is followed, and police verification, medical things were all done. And they have been working in the department for last 10 years.
Yes.
And within this period, your lordship, they have gained enough experience of working in the different department of SAD. Now, putting them in the RCW scheme and appointing new person, your lordship, is very unfair.
Where's the other advertisement which you had annexed regarding the new for the 71 post?
That is at page 81.
Now when they appointed, this is as per the merit list.
Which one?
When they appointed, their merit list was announced.
Yes,
In
it
terms
was
of merit.
published.
Published.
And I have annexed that select list.
Where's that second advertisement?
Second advertisement is page 81.
It has been stayed, this one.
Yes, all ditto.
No, it has been stayed.
Yes,
Is
status quo is maintained. Status quo is maintained.
77 posts.
77 posts of PN.
Okay. Right.
So,
Yes.
Your Lordship will have a pathetic and sympathetic view.
Apathetic, emphatic, or sympathetic? Mr. Shula will continue tomorrow. I've got other engagements. Tomorrow or
Any day, Your Lordship.
Tomorrow.
Friday?
Not on Friday. Then tomorrow, Your Lordship.
You please come to authorities also.
Lordship,
I'll oblige, Lordship.
Thank you.
You have given me enough opportunity.
I gave you on your request.
On my request.
Otherwise, I would have cut short the hearing too. Yes.
I'm so obliged, Your Lordship. But I was hardly so pressed by these 60 people, no.
I can make out by the attitude.
Thank you, Your Lordship.